Okay, we are live back. Joint Minerals Business and Economic Development, July 30th. We're going to continue now, for those joining us outside of here, we'll continue now with 25 LSO 0069, version 7, impact assistant payment percentages. And for that, we've got, okay. Yeah, we're good. Yeah. For that, we're going to have staff. Brian, you take us over, go over the bill, please.
Okay. Yeah, Mr. Chairman, so it's bill draft version 0.7. This is 3-02 in the meeting materials. This is a bill draft drawn up based on the work of a working group that was assigned for this topic concerning payment tiers. Representative Lawley, Representative Larson, Senator Jones, Senator Rothfuss. And this draft would allow the Industrial Siting Council to increase, or perhaps more accurately, seek to increase the impact assistance payments of specified projects that fit into the higher two tiers of those tiers of projects for purposes of impact assistance payments beyond the maximum allowable percentages up to 2.76%. These increases, though, would require approval by the State Loan and Investment Board before they could take effect. So on page 2, lines 12 and 13 are just conforming amendments to reference new subsections that are created. Then, Mr. Chairman, I'll move to page 5 of the bill draft. And this inserts a sentence that says that for industrial facilities with total estimated materials costs exceeding $350 million, that is, those facilities that would be in the second highest tier or the highest tier, the council may increase the maximum allowable percentage to not more than 2.76% in accordance with the new subsection. That subsection begins on page 8 of the bill draft. So begin on page 8 with line 10. For those facilities that exceed the cost above $350 million, the Industrial Siting Council may increase that maximum percentage up to 2.76 in accordance with the following. So first, and this is page 8, line 18, the council must include in the specific findings that the maximum allowable percentage is insufficient to mitigate the identified impacts. Then moving on to page 9. Upon making those findings, the council is then required to forward their findings, the proposed percentage increase, the permit order decision for that project, and the record of the hearing if SLIB requests it, to the State Loan and Investment Board. The next sentence, this is on line 5, says that the State Loan and Investment Board cannot accept or consider any new evidence in its consideration. And then not later than the next regularly scheduled SLIB meeting after receiving a proposed increase, the board must consider that proposal and either, and there's 3 options. They can approve the proposed percentage increase, deny it outright, or modify the percentage to any percentage between the maximum allowable percentage for that tier up to 2.76%. Then on page 10, line 1, the council is required to authorize payments, the impact assistance payments, at a percentage not to exceed the current maximum percentage, so either 1.5% or 2%, while the proposal is pending before SLIB. So payments would be made normally up to that tier maximum before SLIB makes a decision. Then on page 10, line 8, if SLIB approves or modifies that percentage in any way, those payments basically would be retroactive to the local government from the time the payments start when construction commences. Then page 10, line 17, the decision of SLIB to approve, deny, or modify a proposed increase is final, and it is not subject to further review by the Industrial Siting Council, and it is not subject to any judicial review. And then nothing in this paragraph, though, is to be construed to abrogate any other right of review that a party may have under the Industrial Siting Act. Mr. Chairman, the remainder of the bill draft repeats the same thing for use taxes. Then, Mr. Chairman, page 19 of the bill just provides that this applies to impact assistance payments for permit applications submitted on and after the effective date of this act, which is July 1, 2025. With that, Mr. Chairman, I'm happy to answer questions.
Thank you. Committee questions for Brian? There being none, Okay, thank you. Let's go back to Director Profit. Do you want to step in on any of this?
Mr. Chairman, I don't know that we have any specific comments on this, other than recognizing that we would be involving the Office of State Lands and Investment and the State Loan and Investment Board. I think that there may be a representative from Osley online. So if you have any questions there.
All right, thank you. Just thought we'd check with you while we're coming through this. Okay, let's go ahead and, if there's no further discussion on this bill from the committee, let's go ahead and move into taking public comment. We'll pick up on some time going into the afternoon. You folks can stay there. You don't need to move.
Yep, and Mr. Chairman, Jason Crowder, the Deputy Director, is online, should there be any questions for the Office of State Lands and Investments.
Can you bring him on?
Good afternoon, Mr. Chairman.
Uris, what would you like to say about this?
We just greatly appreciate the opportunity to speak to this bill and for you to allow me to appear virtually. We've got a lot going on this week, so I apologize. You've got the B team here. But essentially, what we wanted to say was this is obviously net new for the SLIB board. This is not something that they are accustomed to reviewing, and so we rely heavily on DEQ and the Environmental Siting Council to provide the board or the SLIB board with the information it would need to make the decision as required by the bill. We don't have that process set up right now. This would be, as Director Parfit mentioned, a net new type process for the SLIB board to be inserted into this, and just to highlight that for the board or for the committee, and happy to answer any questions outside of that.
Questions, committee? Questions? Thank you. We don't consider you the B team. Thank you for joining us. Okay. And let's open up for public comment from those in the room. Go ahead, Jeremiah.
Good afternoon, Mr. Chairman, members of the committee. I'm Jeremiah Regan, on behalf of the Wyoming County Commissioners Association. This is a concept that I think we would support. Back a couple of years ago when I worked with Representative Lloyd Larson and Representative Heiner in establishing those tiers, this is a concept that I introduced at that time, but we didn't have enough time to flesh it out. There are also some concerns about providing something new for the State Loan and Investment Board. But this is something that we would appreciate your consideration of. I don't think that this is something that every county is going to avail themselves of. I think we've seen, as the director pointed out earlier, that both requests and approvals have generally been less than the maximum amount that have been available for local governments to pursue. But I do think that there are some instances when we might see the council approve something, or at least recommend something above the existing tiered percentages. I think those would likely be things like a novel project and a novel industrial project that might come forward that we just simply haven't seen in the state, and might warrant additional mitigation to address those unmitigated impacts. I think the other instance is largely to date, these funds have been received by a collection of counties that have seen projects occur year over year. And we're starting to see some of these projects go to new places. I'll just mention like Goshen County with the solar project that's coming, and I suspect some of the rest of you might see projects like that or wind projects in your community. So that might be a place where they haven't had this funding available to them, or a project that has necessitated the funding being available to them, but they might need access to some additional resources to begin to accept that industrial development into their community. So I wanted to just make that in relationship to the possibility of being able to go to SLIB if the Industrial Siting Council ultimately recommended that. Mr. Chairman, I want to go to one other part of the bill. Just quickly, I don't know if this is so much a request that you change anything, but I want to put it on your mind. And I'm on page 4, line 22. And this would apply to several other areas in the bill, but currently the lowest tier has this cap at $350 million. I bring that forward because the Industrial Siting Council, the department, ultimately bring up that jurisdictional number every year. And I don't have a good sense, I don't think the department quite has a good sense of when we're going to see that base number hit $350 million. But at some point, maybe in the next 5 to 10 years, we're going to do that. So we're going to need to ultimately change that $350 million number at some point. Maybe we need to move that to $400 million. I just put it on your mind because, again, that base number, that jurisdictional number does increase over time, and at some point, they're going to meet.
Come
With that,
back and
Mr. Chairman,
summarize that again. Nutshell that one more time.
yeah, so, and what's the current? Okay. Mr. Chairman, the current threshold for jurisdiction, not including those, smaller wind projects, but the current threshold is just around $283 million. The department has a responsibility of adjusting that year over year. And ultimately, that is going to come up and meet that $350 million at some point in the future. And so it's only a suggestion that at some point, we're going to have to change that $350 million. Otherwise, you won't even have a bottom tier here. You're just going to have the upper tiers.
Okay, thank you. Committee for the County Commissioners Association, anything? Okay, thank you. We're going to eventually come back to the subcommittee working on this, but I want to take and see if there's any more public comment from those in the room. Double checking online, nothing. Representative Lawley, you kind of wrap this up for us. Your thoughts, you took a group out and went to work on this.
Thank you, Mr. Chairman. I think those that have spoken, and Brian's explanation is very good. It was just brought to us from some local governments that they could foresee this possibility in the not near future, and especially with expanding costs to mitigate, and things that just to for the board, the idea was to give the council flexibility if needed, with justifications that they would have to have findings that would justify that kind of change. And if they did make a change, the reason we used the SLIB board was just out of a sense of, in Wyoming, we prefer to have elected leaders, elected by the people, review something like that goes beyond what the statute intended originally. And so just as a check. And the SLIB board, I know it's unusual for them, but we did not have any suggestions of a better place to provide that kind of oversight, if you will, by elected officials. So the legislature obviously is a citizen legislature, and we don't meet year-round. So even if a committee or something like that, that would have been a little more problematic. We talked about those options as well, just to know that we had a robust discussion on other possible options, the up and down sides. So I think it's workable. While new, it's workable for that. But again, this is just something to prepare for the future in this area. And so that's what we put it out there to give that flexibility to the Industrial Siting Council.
Representative Lawley, your committee have any strong recommendations on this?
Well, I think we believe it's an important issue. I guess maybe Senator Rothfuss is here. He was on the committee. So I would say there are other issues on our agenda today that I find to be much more timely than this one. But if we wanted to hold it over to the next meeting, see what happens with some of these other bills, then maybe we can make a
Fair enough.
judgment then.
We just
about
want to
what-
acknowledge your work, your subcommittee's
Yeah.
work. Okay.
Thank you.
Senator Rothfuss, do you have anything to add?
Thank you, Mr. Chairman. Yeah, Mr. Chairman, I think this addresses that concern for recognition of the fact that these levels and percentages are relatively arbitrary. The dollar value doesn't necessarily correspond in any meaningful way to what a project is going to need realistically. And having some mechanism to provide an exception in case it doesn't work as intended made sense. And as Representative Lawley noted, the working group felt that SLIB was inappropriate as a group of electeds to take a look at the facts and just say, all right, yeah, this is one that warrants it or not. And providing that additional mechanism was a way to address the concerns that we had heard with this legislation 2 years ago, I think, and since we passed it. Thank you, Mr. Chairman.
Our subcommittee having spoken, anybody else on the committee want to offer comment? Committee, what's your desire? What would you like to do with this bill? I hear a motion. I think at this point, Mr. Co-Chair, I'd still like to have it in the mix as we move into October. Your thoughts?
Mr. Chairman, I think that's appropriate. Not saying a motion, not hearing a lot of strong discussion either way. I think we can carry it over into October, let people think on it a little bit more.
Absent objection, that's what we will do. Thank you. Appreciate the subcommittee's work. All right, industrial siding tribal notification, Brian?
Yep, Mr. Chairman, 25 LSO 41, working draft 0.5, says 3-03 in the online meeting materials. This is a bill draft the committee requested in May that would require the provision of notice to tribal governments of applications for industrial siding permits. So starting on page 2, line 6 is just a definition that would apply to the entire Industrial Siding Act of tribal government. And that is to mean the tribal government of the Eastern Shoshone Tribe, Northern Arapaho Tribe, and the cooperative tribal governing body. The remainder of the changes, Mr. Chairman, are just inserting generally references to tribal governments in places that describe notice, generally to local governments, of proposals or applications for industrial siding projects. So page 2, line 21, this is in 3512-107B12 concerning required information in the waiver request that just requires a certification from the applicant that all tribal governments within the potentially impacted area were provided notification. Page 3, lines 8 and 9, and then 17 and 18 are requirements for the director of the department to serve notice of the waiver request to the tribal governments and then later of a meeting concerning that waiver to tribal governments. That's page 3, lines 17 and 18. Then on page 4, lines 4 and 5, this concerns the director's duties in providing notice of a hearing on a waiver to the application. Just inserts a reference to tribal governments if applicable. Then on page 4, this is moving into 3512-109, which concerns the actual application for the permit. The previous section deals with a waiver process that I think in practice is rarely used. So page 4, line 18, this is again a certification from the applicant that all local and now tribal governments that will be primarily affected were provided notification and a description of the project. Moving on to page 5, line 10, this concerns notice of the application and would require the director to serve a physical copy or electronic copy of the application to the tribal governments that will be primarily affected. Page 5, line 21 and 22, this concerns notice of a hearing on the application. It just requires the director to provide notice to tribal governments if applicable. Then moving on to page 6, this is in 3512-113C on line 11, concerning modification of a facility location, just inserts a reference to tribal governments for notice of a modification. Then in subsection F, concerning the modification decision, just inserts tribal governments to have that decision be served upon them. Then page 7, line 4, just provides that the act applies to all applications submitted or filed on and after the effective date of this act. rulemaking and then split effective date. Mr. Chairman, the one thing I would note about this draft, my thinking with the way it's drafted is that this would not make the tribe a party to that process. This is only meant to provide notice of the application, notice of hearings, notice of decisions to the tribal governments. With that, Mr. Chairman, I'd be happy to answer questions.
Thank you. Committee questions for Brian? Go ahead, Representative Lawley.
Thank you, Mr. Chairman. Brian, to your very last point there, I agree that it didn't say that, but do you have any view on whether or not that should be made a little bit more clear in a more affirmative way in the bill?
Brian?
Yeah, Mr. Chairman, Representative Lawley, whether, more explicit language is needed, I would certainly defer to the committee. The department's view is as well on that. 3512-111, and this is A2 in particular, which provides the parties to a permit proceeding include the applicant and then each local government. And so that was one place very specifically in this draft that there is no addition of tribal government to that language. Could there be other ways to draft this to make that clear? Certainly. And I would, welcome any direction from the committee.
Follow up? Good. Committee, anything else for Brian? All right. Okay, let's move it into, Director, you have anything to offer on this, or Doctor?
Yeah, thank you, Mr. Chairman. Well, first off, I would say the notification to the tribes, we think that's a good idea, and throughout the draft bill, we think that that's appropriate. I would suggest that the committee take a look at 3512-111A3, because I do believe that these changes would provide the opportunity for the tribes to become a party because of that particular paragraph. So just so you know where that resides and the direction you want to go with that.
Thank you. Doctor, don't want to bypass you, you good?
My only comment is to concur with Mr. Parfit.
Okay, thank you.
It's always a good comment.
All right, I'd like to see more of that in our families, my golly. Let's open it up for public comment. No further public comment here and nothing online? Committee, what would you like to do? Oh, go ahead. Okay, Ms. Pope, are you out there? Go ahead, sir. You hear us?
Mr. Chairman, yes, I can hear you. Hi, this is Jeff Pope again, partner at Holland and Hart. On behalf of the same group of folks who I was here on behalf of before, just without the introduction. I just wanted to make two quick points about this particular bill. The first, which the director covered, is I agree that it certainly could be read based upon the director's citation to 3512-111 to allow the tribes to be parties to the permit hearing. From the perspective of industry, that introduces the potential of a new objecting party. Certainly the goal of industry and the goal of someone who represents industries who go through this process is to minimize the potential objecting parties. Not to cut them out of the process, but I think it either needs to be made clear in the legislation that they can be parties, or made clear that they should not become parties to the permit proceeding. To the extent there's concern about a project that would be located on tribal lands, that the act as it sits now already accounts for that. They would be considered an affected landowner and would become would receive notice, would get party status and have all of those protections. So this is just kind of a variable, at least the way it's drafted. The second point I wanted to make, and it's just an uncertainty, a little bit less for the industry, but as someone who has to advise on the whole of the process, it's a little unclear of whether or not tribal governments now or in the future would be eligible for impact assistance dollars. Typically, the local governments who receive notice are the ones who would become eligible for impact assistance payments. Don't know if the committee wanted to do that or is thinking of doing that, but I wanted to flag that that is the potential for this bill to lead to something like that without clarification language, precisely because the local governments who receive notice are involved in that process. So with that said, happy to stand for any questions.
Questions for Mr. Pope, committee? Go ahead, Senator.
Thank you, Mr. Chairman. Mr. Pope, that last part, I don't understand why it would be read to lead to that potential for distribution to a local government, including tribal governments, based on the rest of statute, even with these changes. So can you point us to where you feel that confusion could arise? I understood the first part, but I don't see statutorily that last bit.
Mr. Pope.
Mr. Chairman, Senator the Rothfuss, apologies if I was unclear. I don't read the bill to make tribal governments eligible for impact assistance payments as it's drafted. One of the things that I think I would have concerns about as a practitioner in this area is that that could be read as the direction of the legislature, because affected local governments who receive notice primarily receive that notice so they can participate in the impact assistance process. By interjecting tribal governments into that same notification procedure, I would suspect I would have clients ask the question of, well, does that mean the legislature intends or will at some point make that another group of local governments, or in this case, tribal government, eligible for impact assistance payments? Apologies if that wasn't clear.
Senator, follow-up?
Yeah, Mr. Chairman, we do these kinds of things where we draw lines all the time, though. I don't understand why that question coming to you would be a concern. Maybe I'm missing something there. My expectation would be that you would say, I don't know what the legislature is going to do in the future, any more than I know what the legislature is going to do in the future as a legislator. Would that not be the approach?
Mr. Pope?
Thank you, Mr. Chairman. Senator Rothfuss. The reason I would suspect my clients would ask that is very often they, very early on, before they've even had a jurisdictional meeting, approach local governments who would be eligible for impact assistance payments to potentially find ways to participate in that community, make donations, figure out ways to mitigate any impacts of the project. So the question I often get asked is, who are, what entities, if you will be eligible for impact assistance dollars? And for better or worse, I do get often asked how to forecast where the legislature is going. I have no more insight than you do, Senator Rothfuss, but I wanted to flag that I would suspect, based on my prior conversations with the folks who go through this process, that they will try to anticipate whether or not tribal governments will become eligible for impact assistance payments for precisely that same reason, so that they know whether to engage with those governments early or whether they do not need to engage.
Thank you.
Follow-up? Good. All right. Committee, anything else? Go ahead, Representative Lawley.
Thank you, Mr. Chairman. Do you feel, am I hearing these are two different issues in your mind, of a clear statement concerning the limitation of the tribe's role, and what we're not granting here is not enough to address your second issue concerning whether or not the legislature might be intending somehow for them to receive these payments? I just want to understand, would a clearer statement clear that up of what the limited role is in terms of the tribes in this bill under this amendment? Would it help the second for you or not? Is that just a whole separate issue?
Mr. Pope?
Thank you, Mr. Chairman. Representative Lawley, I do think a clearer statement of what it is the legislation is trying to accomplish would help on the second question. If, and I don't want to presume to tell you how to put it in there, but if there was something to the effect of, this is simply to provide notice, and there are no either party status rights or any other rights that go along with that, that would I think, provide the clarity where I would be able to tell my industrial clients, how to navigate their engagement strategy with local communities, and also to be able to predict who and who is not a party to a permit hearing.
Representative, good?
Yeah, thank you. That was very helpful. I think it helps us understand the need for a clear statement.
Thank you.
And courts can take the ambiguity and do all kinds of things we cannot imagine.
Thank you. Committee, anything else? All right, have we double checked the room? Any other comment? Nothing else? Oh, go ahead.
Mr. Chairman, when we're open for discussion, I didn't see anyone else wanting to testify, and just wanted to offer some information if I could at this point.
Please do.
So this was an idea that I had at our last meeting, and since that time, Brian and the members from DEQ and Industrial Siding that you see before you, we sat down and had a meeting. And so we hashed through a lot of these issues and looked at the entire Industrial Siding Act. And look, there might be, recognizing there might be some areas where it would be appropriate to add and tribal and include the tribes in notification. And so we did have this kind of open-ended discussion on how far does this need to go? Do we want to have that conversation about making tribes eligible for impact assistance, or financial assistance? My understanding is that for this meeting today, there's maybe a bill draft in the works, but not ready today for this hearing. And so it's just a matter of timing that we're trying to sort through. Tribal Relations meets again on August 26th. These bills haven't been fully presented to either of our tribes, and so I don't want to relay to the committee that there's support or non-support. So it's kind of ongoing. I think that is the question that we'll be seeking from the tribes is, do you want just the notification, or do you want it to be something more? And maybe perhaps being eligible to receive some financial assistance. I've been talking with one of the representatives that represents the tribes, and there's some other questions that DEQ, when they present this bill at Tribal Relations, can help answer. The status of lands, where the project's located. And so that's my understanding, Mr. Chairman, is this bill I don't think is ready to move today, but it's an important first step in this conversation. So, if Brian has any other comments beyond that, but I believe a second bill draft might be in the works that we can present to the council, the tribal councils, and then bring back to Minerals hopefully for our last meeting.
Brian, do you want to offer follow-up? No? Okay. Committees, Senator Ellis, do you have any questions for Senator Ellis?
Mr. Chairman, I would just ask for Mr. Pope. I think he's aware that this is an important issue for me. So if he has any other further concerns about how we can add clarity to the bills, that he reach out to me directly, and we'll make sure that that's incorporated as we continue to work these issues going forward.
Thank you, Senator. So as we understand you, then we're going to put a hold on this and carry it forward.
Mr. Chairman, I would hope there is no motion on this bill today.
You heard it, folks. Absence objection. No motion? There's not. Senator Ellis, your wish. Very good. Let's move forward then. Okay, we're moving into what would be our normal schedule, just a little bit behind. We picked up some time at lunch. Appreciate everybody hustling lunch a little bit more. Let's go to 0040 and manufacturing sales and use tax exemption amendments. Brian?
Yep, Mr. Chairman, this is, so draft 0.4, 5-01 in the online meeting materials. This is the bill draft that the committee requested in May and does two things. First, it extends the sunset date for the manufacturing sales and use tax exemption, and then it makes changes to align the use tax exemption language to the changes for the sales tax language that were made in 2024 House Bill 197. So page 2, line 9, this changes the sunset date for the sales tax manufacturing exemption from December 31, 2027 to December 31, 2037. 10 years was the number from the May meeting. Page 2, line 22 makes that same sunset date change to the use tax. And then page 3, line 2 is just striking language as a conforming amendment. Then page 3, lines 4 and 5, this repeals 3916-105A8D subdivision 1 and 2. And these two subdivisions, which are the full language of which are on the bottom of page 3 in the staff comment, specify requirements for a sale or lease to qualify for that exemption, including sale, being a sale to a certain NAICS code manufacturer and the exclusion of non-capitalized machinery. This repeal would align the use tax exemption with the sales tax exemption and those changes made in the 2024 session. It would be effective July 1, 2025. With that, Mr. Chairman, stand for questions.
It is. Committee questions for Brian. Okay, there being none, let's go ahead. Represented.
Mr. Chairman, thank you. Just a question for Ryan, and I apologize for not knowing the answer. Why were the NACS codes removed?
Brian?
Yeah, Mr. Chairman, Representative Conrad, at least for purposes of this bill draft, that was a direction from the chairman to make changes to the use tax language that were made in a 2024 House bill. I immediately recall if that was one revenue sponsored, if it was an individual who sponsored that bill draft. So beyond that, why those two provisions were removed from that 2024 bill, I wouldn't be able to answer that, Mr. Chairman.
Representative Coverett? Okay, thank you.
Chairman?
Go ahead, Co-Chair.
Mr. Chairman, excuse me. If you remember from the 2024 session, and I believe it was revenue, had a bill which passed, which removed, in effect, the mirror sections in the sales tax statutes, but left in these in the use tax section and that. So this is merely to conform what we've done, because sales tax, use tax fall under what we would call excise tax. It's more how you pay for them, and that rather than getting taxed. I would ask the department if they want to speak on that issue. That they're fighting among each other right now for spot at the table.
And Mr.
But-
Chairman,
Go ahead.
I would say, if you go and buy a $100 drill at a hardware store, you pay 6% tax. If you order it from somewhere, in effect, when you get it and if they don't collect the sales tax and you remit it, that's the use tax, in my mind, and the department can correct me. So it has to be paid, but what we've in effect said, if all you're paying is use tax, if we don't remove this, then the old rules follow, but if you pay sales tax, then it's the new rules. And it's confusing, so I would say that's the reason to change it.
Do you need to follow up, Brian, or?
Do not.
Okay, let's go to the department.
Thank you, Mr. Chairman, members of the committee. I'm Brett Fanning, the Excise Tax Administrator at the Wyoming Department of Revenue. Mr. Chairman, Mr. Co-Chairman, I think you've kind of nailed that on the head. It really relates back to House Bill 197 from last year. And in that bill, it only referenced the sales tax portion of it. And it was a thought that maybe this year there would be some type of revisor bill to align these two statutes together. So as of right now, this is just the conforming language. So in general, sales tax, that's paid for when you purchase something that is sales taxable in Wyoming and you pay it to a Wyoming vendor or someone who is licensed to collect Wyoming sales tax. So a lot of us just went and had a great meal at lunch, paid sales tax on that when you had your meal, sales tax. Use tax has very similar statutes in our statute book. Use tax is comparable to sales tax, but it's when you purchase something generally from online or out of state, you aren't charged sales tax, and then you bring it into Wyoming for storage, use, or consumption. They are meant to align in our statutes. This language with the NAICS codes is just conforming based on the legislation that was passed last year.
Committee, follow up for the department? Oh, go ahead. Senator?
Thank you, Mr. Chairman. Is the Revenue Committee aware of this?
Sir?
Mr. Chairman, Senator Ruffs, I do not believe so. This is something that we were believing was going to be in a reviser's bill that would come this year, but as of this point, I'm not sure they're aware.
Senator Rothfuss?
Yeah, thank you, Mr. Chairman. From a reviser's bill standpoint, it might be a stretch for the reviser's bill because it actually changes policy in a substantive way, even though the intent was there. If it has a change in policy outcome relative to what's being done right now, the reviser's bill would struggle to that. But having a revision certainly makes good sense. I think the intent, as it always is to mirror those two. But I guess I question the Minerals Committee being the responsible committee relative to revenue. So I was just curious if you'd had discussions with the co-chairman of Minerals or anything along those lines, of the Revenue Committee along that same path. It doesn't sound like those conversations have started. Okay, thank you.
Do you want to follow up to any of that?
Nope, I think I'm good, Mr. Chairman. Thank you.
Cover that? Okay. Anyone else from within the room? We have anybody online on this? Oh, go ahead. Mr. Detai?
Thank you, Mr. Chairman. Travis Detai with the Mining Association. In support of the bill, recall this was a request for the interim from the mining industry. Really appreciate you taking a look at it and really appreciate the extension of the sunset date. Appreciate the committee's work on it.
Thank you. Committee? Being none, go ahead, sir.
Mr. Chairman, just a reminder, Chris Mickey from the Wyoming Business Alliance. We also are in full support of this bill. We believe that extending the tax exemption will further incentivize businesses in the manufacturing industry to choose Wyoming as a place to do business or expand their existing business. By doing this, we can create more good-paying jobs, maintain a sound business environment for the industry, and further diversify Wyoming's economy. So with that, Mr. Chairman, we just want to
Thank you.
offer our full support. Thank you.
Committee, any questions? Thank you, sir. Oh, go ahead. I missed you. Go ahead.
And you may not have the answers, my apologies if you don't, but how many states have a manufacturing sales tax exemption?
Go ahead.
Mr. Chairman, Senator Rothfuss, I don't have that information for you at the time, but I will look into it for you.
Okay, and Mr. Chairman, the follow-up, which again, you may not have at this time, but I'd appreciate follow-up later. We passed this quite a few years ago, and it seems that it didn't end up attracting any major manufacturers into the state of Wyoming. I'm not saying zero manufacturers. There have been some smaller manufacturing facilities that I think have taken advantage of this. But my recollection on many of those is that, this might have been an add-on advantage, but they had other reasons for choosing the state. So has there been any analysis that you're aware of to see whether this policy was actually effective? Again, we really struggle to have manufacturing in Wyoming. We've had this on the books for a long time. I'm curious to see if it's actually achieved what you suggested it might.
Mr. Mickey?
Mr. Chairman, Senator Rothfuss, just anecdotally, we have seen some folks take advantage of this and working. As far as a data standpoint, that would be something I could work and get you.
Very
Great,
good.
thank you.
Good, Senator. Thank
Good,
you.
thanks.
Anyone else? Mr. Mickey, when you find out that number of the other states, just do an all committee send on that. Thank you.
Yes, Mr. Chairman.
Appreciate it.
Mr. Chairman,
Oh, go ahead.
Mr. Kidd had raised his hand. He's on Zoom.
Okay, let me double check with the co-chair. Were you going to say something?
Mr. Chairman, I just got a text. Sometimes these things really are useful. Revenue Committee is aware of this, but took no position on it one way or the other. They had no comment, but they are aware of this bill and what it does.
Thank you for the background. Mr. Kidd, welcome back.
Thank you, Mr. Chairman. Members of the committee, I'm here on behalf of the Alliance of Wyoming Manufacturers. The Alliance is focused on the future of Wyoming manufacturing, ensuring manufacturing industry in Wyoming is a source of skilled, continues to be a source of skilled, good paying jobs. Just like to reiterate the comments that have previously been made regarding the sales tax exemption for manufacturing, and appreciate the committee extending that sunset date, and the Alliance is in full support. And I'll go back to our members and see what additional data we can provide, going back to Senator Rothfuss's question, and provide that to the committee as well.
We would appreciate that. Thank you. Committee, Mr. Kidd, questions? There being none? Okay, thank you, Mr. Kidd. Appreciate you coming back.
Thank you, Chairman.
Okay, anybody else online or in the room? Committee, what's your pleasure? Go ahead.
If there's no further discussion, I'd like to move the bill forward.
Do we have a second? Second. Moved and seconded. Okay. Let's double check with Brian one more time. Anything else we need to be aware of on this?
Yeah, Mr. Chairman, just to note this, the 2024 House Bill 197 was individually sponsored. I took a look at the bill summary, and the summary just describes basically the purpose of the bill as to conform to practices of the Department of Revenue. The bill makes a number of other changes beyond just having removed that language from the sales tax provisions.
All right, thank you. Committee, any amendments? Page 1, page 2, page 3, page 4. No amendments. Ready for roll call? Go ahead.
Thanks, Mr. Chairman. I'm going to be against this bill. There's a couple of reasons. First, this really is the purview of the Revenue Committee. It should be going through that committee, and I don't know why they're not doing it through their committee. It's the appropriate place to discuss it. And this is down the center of the plate for revenue. It's clearly revenue. It'd be like an oil and gas bill on spacing going through the Revenue Committee. That's the wrong process. So even if we support this, I think the process is important. It could come as an individual bill, but having a committee like Minerals or the other one I serve on, Education, for example, sponsoring a revenue bill is just contrary to process. So on those grounds, I have concerns. The other side of it is we've had a few exemptions on the books for quite a few years, and the idea that we would pass this without looking at the data and finding out whether this is working is of concern, because I know that we do these things because we're competing with other states to try and recruit. And those other states are lowering their taxes to compete with us. And that's how we have the data center, for example, right? The data center tax exemption is because all the other states had data center tax exemption. So the only way we could have a data center is if we succumbed to that pressure and had the exemption also. So that was an industry that did a tremendous job of lobbying, got all of the states on board by playing states against each other, and effectively exempted themselves from taxation. I don't understand what it is about manufacturing that we would give an exemption to where we wouldn't give it to coal, oil, and gas, which have treated us well, right? These are industries that have really helped the state of Wyoming. We're going to keep taxing those industries because we have to, because they provide a tremendous amount of revenue. But when you create disproportionate taxation and you choose one industry, one sector, manufacturing, for whatever reason, we're going to say you're exempt. Data centers, we've already said you're going to be exempt because other states did it. I don't know why we like manufacturing better than coal, oil, and gas, or any other mineral industry, or really any other industry, wind industry. What's special about manufacturing that makes this committee, the Minerals Committee, decide that we want to treat it preferentially better as an industry than the industries that have actually floated the state for certainly as long as I've been in the legislature? I don't think that statement's a good statement. We have to have revenue for the state. We can't just get rid of sales and use tax. If we could, that would be fair and equitable, but would cause some serious challenges elsewhere. So for those reasons, I do not want to continue to disproportionately favor manufacturing over the industries that have helped the hardworking people of the state of Wyoming for so long.
Committee, for or against, any further comments? Representative.
Mr. Chairman, thank you. I thank you, Senator Rothfuss. I would just remind the committee that this is actually as well joint minerals, business, and economic development. And I feel that it fits nicely within the body of this discussion and/or committee. So just to note, economic development is the primary purpose in this, at least from my perspective.
Thank you. Co-chair, would you repeat what you said about the information that was provided to revenue on this, yet it's back in our body?
Thank you, Mr. Chairman. Sorry, I was trying to look up the statutes. Couple things. Minerals knows about the bill. They know it's up in this committee.
Revenue
I'm
knows.
sorry, Revenue. And took no position other than anecdotally, they've said, yeah, let Minerals go ahead and handle it. They're still fooling with property taxes, working property tax issues. So they've given us, kind of authority to go ahead and take this up, which is one thing. Some of the original issues on the manufacturing tax exemption was to diversify the economy, to bring manufacturing in, which Wyoming is very light in real manufacturing. We don't produce much other than minerals. To bring a wind turbine manufacturing company and a jet engine manufacturing company or any number of things, it was to stimulate that. And that was my recollection for the reason that I've heard for that. So Revenue knows what we're doing. They don't have an objection to it. I think we can take it from there.
Thank you for that summary. Any other comment from the committee? We have a motion on the floor. Motion was do pass, and it was seconded. Without any further comment, we'll take roll.
Senator Cooper?
Aye.
Senator Ellis? Aye. Senator Jones? Aye. Senator Rothfuss?
No.
Representative Banks?
Aye.
Representative Conrad?
Aye.
Representative Heiner?
Aye.
Representative Knapp?
Aye.
Representative Larson?
Excused, if he's not on the screen.
Representative Lawley?
Aye.
Representative Tarver?
Aye.
Representative Western excused.
Excused.
Co-Chairman Burkhart?
Aye.
Chairman Duckstetter?
Aye.
That passes.
Okay, thank you. Manufacturing sales and use tax exemption has passed the committee. Let's move to industrial production inventory exemption. Brian, if you've gathered up your thoughts, we'll go back to you, sir.
Yep, Mr. Chairman, members of the committee, 25 LSO 44, draft 0.6, industrial production inventory exemption. This is 5-02 in the online meeting materials. This is a bill draft that the committee requested at its May meeting and would provide a property ad valorem tax exemption for the storage of industrial equipment in the state while that equipment is in storage and is not installed or otherwise used. The staff comment on page 2, Mr. Chairman, just notes that the term temporary is the term that is used to describe the storage exemption. And the committee may wish to consider defining what that period is, i.e. how long could the industrial equipment remain in storage and receive the exemption, or if some other term should be used to designate what is meant by that temporary or non-permanent storage. So page 2, line 22, this provides that property that is stored by the purchaser in this state before the first installation of the property as industrial production equipment is exempt from ad valorem taxation in accordance with subsection C, which begins on page 2, line 28. So this equipment that is stored in Wyoming before the first installation shall be exempt during the temporary storage or inventory period in accordance with the following. On page 3, line 7, so on line 5, these are definitions that would apply to the subsection. So first, line 7, commercial storage facility is one where the industrial production equipment is temporarily stored and a facility that has been approved by the Department of Revenue. Page 3, line 12 defines industrial production to mean any of the following. So manufacturing, milling, converting, producing, processing, or fabricating materials, the extraction or processing of minerals, the mechanical, chemical, or electronic transformation of property into new products. On the top of page 4, agricultural activities, and then finally, other industrial activities. Page 4, line 5, industrial production equipment is defined to be any equipment designed specifically for use in industrial production, which was just defined before this. It includes pipes necessary for pipelines used for the transportation of minerals, and it excludes both manufacturing machinery that is exempt from sales and use tax and mobile machinery. Mobile machinery is the next definition on line 13, and that's any equipment, machinery, or vehicle that can move from place to place under its own power, or that can be moved or towed from place to place, including machinery, equipment, or vehicles that are used to transport industrial production equipment. Then page 4, line 20, to qualify for this exemption, sales and use tax must be paid on the property upon removal from the commercial storage facility, and that sales or use tax must be paid on the property in the county where the property is installed at the rate imposed by that county. Then moving on to page 5, line 5, the county assessor or the Department of Revenue may require any documentation that is necessary to verify that the industrial production equipment is eligible for this exemption. Line 10, to qualify for the exemption, the industrial production equipment shall be temporarily stored or placed in inventory at a commercial storage facility that has been approved by the Department of Revenue. Line 15, that equipment that qualifies for the exemption may remain eligible if it remains in temporary storage or inventory, provided that the equipment isn't installed or fixed for use in industrial production. Then page 6, line 1, provides exceptions to the exemption. So the exemption does not apply to industrial production equipment with a sales price of less than $50,000, mobile machinery, and raw materials that are used in industrial production. Page 6, line 13, provides rulemaking requirements for the Department of Revenue, including rules that require taxpayers to notify the department of the purchase, storage, and installation of qualifying equipment, requirements and qualifications for a facility or location to qualify as a commercial storage facility where this equipment may be stored. Then page 7, beginning with line 7, this is a new subsection in 3915-104F to clarify and provide that the retail sale of the industrial production equipment shall be sourced to the location where it is installed or intended to be installed for permanent use or occupation. Page 7, line 19 is the same concept in the use tax statutes. And then this bill would be effective July 1, 2025. With that, Mr. Chairman, happy to answer questions.
Committee questions for Brian? Go ahead.
Mr. Chairman, thank you. On page 6 there, letter A, what's the reason of that threshold there of the 50,000 or less?
Brian, want to answer that?
Yeah, Mr. Chairman, I think that may be a question better suited for the co-chairman.
Mr. Chairman, if I might.
Let's let co-chair answer, and then I'll come down to you.
Mr. Chairman, I felt it was appropriate to put a number in there so that you don't have people claiming an exemption for small items. This is mostly for large industrial equipment. You know, a pump jack, for example. They buy multiple ones and store them until they're installed. And so that was a limit. It's an arbitrary number, but I thought that it was necessary to have something below that, that they get charged for. I mean, someone buys a milling machine and puts it in storage and it's only $10,000 and lets it sit there. I think they ought to just pay what they need to pay. But it's for the larger equipment that is not mobile.
Representative Banks, that answered? Okay, thank you. Did I hear someone else's voice? Senator Ellis?
Thank you, Mr. Chairman. Mine is a drafting question on page 4. My understanding is on lists. Whenever LSO drafts, the new convention is when you have a list, the presumption is that it's an and. And so we've got a list of 5 things. Does it need to say or after agricultural activities on page 4, line 1?
Thoughts on that, Brian?
Yeah, Mr. Chairman, Senator Ellis, I think it's covered on page 3, lines 12 and 13, with the reference any of the following.
Senator Ellis, okay, good. Questions, committee? Committee questions? All right, let's move into the room. Anybody in the room would like to comment? Anybody on screen, on Zoom? No? Oh, the department, we have almost bypassed you. Director Hanson. Oh, you're bringing friends, okay. It's all yours, Director.
Good afternoon. Brenda Henson, Director of the Department of Revenue. Good afternoon, committee members. With me today, I have Ken Gill, the Property Tax Division Administrator, and also Brett Fanning, the Excise Tax Division Administrator. On this particular bill, as Brian just explained, you've got 2 very different concepts within this bill. The first being an exemption for property taxation of equipment that is being stored in a commercial storage facility and basically provides an exemption until that equipment is first installed. That's a property tax exemption, recognizing where property tax dollars go to the local level. The second portion of this bill is a sales tax sourcing component. And it's much different than how we source sales tax for any other transaction. So I think it's important that we cover both of these separately, conceptually, because either one of these concepts could move forward on their own. You could have an exemption for personal property that is held in a commercial storage facility, standalone. You could also change the sourcing language for those types of purchases that are mentioned here. If I may, Mr. Chairman, probably one of the things that would be easiest is to just kind of go through the bill. I've just got a handful of comments First and foremost, the
Let's make sure the
title,
committee's ready. Director's going to take us through the bill to give us a few heads up there, okay? Go ahead.
fairly quickly. The title of this bill is Industrial Production Inventory Exemption. So it should be noted in Chapter 13 of Title 39, we define inventories. Inventories are defined as personal property held for resale. So any place within the bill that you see the term inventory, that is not equipment that has been purchased by an end user. So I would encourage the committee to consider a title that would be temporarily stored industrial personal property tax exemption, if the committee wishes to move forward with that. One thing to consider on page 2, the staff comment relates to temporary. So for property tax purposes, we assess property taxes as they exist to the owner of record on January 1 of each year. So if a property owner, a business owner owns personal property on January 1, 2024, they report it no later than March 1st, we tax that for 2024. If they acquire that property anytime after that, they don't report that for property tax purposes. It isn't even taxed until the following tax year. So you've got up to a 12-month period. Now, whether that company purchases it in June or they purchase it in January, it's still not going to be assessed until January 1 of 2025. So that's a concept for property taxation to just keep in mind. So as we move forward on page 3, that's one of the areas on lines 1 through 3 where it talks about exempt from property taxation. I would suggest when temporarily stored in accordance with the following, and just eliminate the inventory period, because that makes it sound like I'm a business and I've got personal property for resale. And that's already exempt under Wyoming statute for property taxation. The next component is reflected on lines 7 through 10. Commercial storage facility means, and then it goes through a requirement that this commercial storage facility has been approved by the Department of Revenue. So in order for a company to apply for the exemption for the personal property that they own that is being housed in a commercial storage facility, there's got to be a mechanism there for the Department of Revenue to become aware of these commercial storage facilities. We certainly have no knowledge of where they are located. So we believe that there should be an application process or some sort of a process where a commercial storage facility identifies themselves. We approve them as such, so that following then the business owner that owns that equipment that's in that commercial storage facility can be granted the exemption. You can't have one before the other. And hopefully that's clear. Mr. Chairman, starting on page 3, where it talks about industrial production means any of the following, it is my assumption that the number 3, the mechanical, chemical, or electronic transformation of property into new products will be left to the Department of Revenue to define exactly who we're trying to provide. What type of equipment are we trying to provide an exemption to? The same thing holds true with page 4, number 4, agricultural activities and other industrial activities. Just would ask that this committee perhaps give us a little more guidance as to, I do believe 1 and 2 are fairly clear, but 3, 4, and 5 seems somewhat broad, and we certainly don't want to overstep our authority in the rulemaking process. Mr. Chairman, on page 4, down at the bottom, where it states Romanet 2, to qualify for the exemption under the subsection, Wyoming sales and use tax shall be paid on the property upon the removal of the property from the commercial storage facility. So I was trying to, okay, this is our sourcing laws, and I have the experts on these beside me, but the sourcing laws. So if we remove it from that commercial storage facility out north of town here, the moment that it's removed from the commercial storage facility, then the Wyoming sales and use tax shall be paid on that. So we have a need for some guidance because this bill is saying that the sales tax or use tax needs to be paid before they can qualify for a property tax exemption. But yet, when companies put equipment in these storage facilities, many times they are not completely sure of the intended destination of that equipment. And so we're somewhat concerned about exactly when does that sales tax become due? Because this seems to lead it that it's not when they bought that equipment. That sales and use tax does not come due when they purchase that equipment from a vendor, that they somehow are going to be exempt from paying sales tax at that point, and the sales tax will actually come due upon the removal of the equipment from the storage facility. And then I'll leave it at that. It does reference throughout the bill, the county assessor or the Department of Revenue may require, and it's just important to note that this language that is proposed affects both locally assessed companies that are valued and taxed at the local level by the local county assessor, and that it also impacts those state assessed properties, public utility companies, telecommunications companies, railroads perhaps, pipeline companies, we see that referenced. Those are all valued by the Department of Revenue. And so we believe that we can clarify within rule how each of these application processes will flow related to whether it's local assessed or state assessed. Mr. Chairman, again, on page 5, where it talks in Romanet 5, to qualify for the exemption, it shall be temporarily stored. There's another spot there where we're placed in inventory that could be eliminated. And on page 5, line 12 is also a reference to inventory. Yeah, that's the one. There's several places, if they could do a search for the word inventory and remove that from the bill so that there's no confusion that that should somehow be considered in this exemption.
Okay.
On, let's see, there's just a possibility that the committee may want to consider splitting these concepts. On page 7 is where we really start talking about the sales and use tax and the possibility of the sourcing being changed. The way this is drafted, the sourcing would only change for equipment that is purchased and then taken to a commercial storage facility. So the question for the vendor that just sold that piece of equipment is, how do they know whether they're responsible for collecting that sales tax or use tax at the time of sale, which is how we treat everything else? Or are they delivering that equipment to a commercial storage facility, in which case they shouldn't be collecting sales tax at the time of the transaction? And Mr. Chairman, with that, again, I do have those folks that deal with this every day, and if I have missed something, I invite both of you to chime
Open
in.
it up to your colleagues, all yours, gentlemen. Anything? Thank you, appreciate it. Mr. Co-Chair, you put some work into this. You want to comment before we open it up to the committee?
Mr. Chairman, excuse me, thank you. I think we had an idea, of what the department would say. This was a bill to get the conversation started. We still need to work on it and work on a lot of the language and a lot of the wording, but it was the concept that we wanted to introduce at this meeting to allow companies to use a deferral, and I'll call it a deferral, not an exemption on some of this stuff. The sales tax would be merely deferred, not exempted. And so probably need to change as the department said, change the title. I think we need to look at working a number of these sections, and I guess cut to the end real quick, probably need to hold this over and work on it between now and October.
Okay. Before we go back to Brian, committee, anything that you would want to add? Senator, go ahead.
I did have a couple of questions. The first is with regard to the location issue that was mentioned. I know right now, and this was an earlier discussion on earlier versions of this bill, discussions related to what county beneficial use goes into effect, and therefore where the sales and use tax is registered. How, based on this draft, how would you perceive that beneficial use taking effect? Would it then be always in the county where the storage facility is located? So even if it's a storage facility for a new wind turbine development, we'll say that wind turbine development is located in Carbon County, but the storage facility is in Casper. I would take this as written as paying all of the sales and use tax in Casper as the beneficial use event according to statute. Is that how you would perceive it, or would you still have flexibility under other portions of law to say, no, that's being put to beneficial use in Carbon County, and therefore we would credit the sales and use tax under the use side to Carbon County? Any sense of that from this draft?
Director Henson.
Mr. Chairman, Senator Rothfuss, so as the law currently exists, if you have a company that is building a wind farm in Carbon County, and that company purchases equipment, parts, and has them delivered into Wyoming to the storage facility in Natrona County. Under current statute, that sales tax is sourced to Natrona County because that is where the company took possession. Even though it's in a storage facility, the vendor no longer owns that equipment. That was taken possession in Natrona County. So we really don't have a discussion within statute that talks about the beneficiary of, where is that equipment going to ultimately exist. That is a much broader discussion, not limited to just storage, commercial storage facilities, but it is a discussion that not only impacts the state of Wyoming, but the way our sourcing laws exist are in compliance with the streamlined sales tax agreement. And Mr. Fanning can expound on that related to what options exist for Wyoming law to source sales tax somewhere other than where the customer takes possession.
Sir, go ahead.
Thank you, Mr. Chairman. Thank you, Director Henson. Brett Fanning again, Excise Tax Administrator. So we are part of the streamlined sales tax agreement, and so we follow their guidelines and procedures. Now, in the provisions of that agreement, there's really two kind of concepts that come to mind that kind of go to this beneficiary use that you're talking about, Mr. Senator. The first one is called a direct pay permit. And this is where you provide a direct pay permit to that vendor saying, hey, don't charge me sales tax. I am going to charge sales tax to myself and send it into the state. And that's kind of one option, direct pay permit. So they're telling the vendor, because remember, this is kind of one of the tricky things that we have here. The vendor's selling it somewhere, but it's ultimately going to be used somewhere else. And that's the main topic of this discussion, at least from the sales and excise tax part of it. The second option that's a possibility is some sort of exemption in our Wyoming sales tax statutes that has a provision included within it that says, hey, vendor, don't charge sales tax on industrial production equipment. And then the purchaser is then responsible to send the sales tax into the state of Wyoming. Both of those concepts allow the vendor to not charge sales tax and be protected because they have an exemption certificate on file. That's their get out of jail free card if they don't charge sales tax. Both of those two options allow the vendor to not charge sales tax, and then we can really work in these sourcing statutes, because then the liability, or that's not the right term, the responsibility of sending in the tax to the state of Wyoming is on the purchaser, and then we can work in these sourcing statutes.
Senator, you good?
So under that scenario, if there was a desire to ensure that sales and use tax, and it sounds like it's not even done right now, but if there were a desire to have the sales and use tax for a turbine farm that was placed in Carbon County to actually end up with Carbon County rather than place of sale arbitrarily in Trona County, how would we statutorily provide that type of a directive based on the streamlined sales tax structure that you just laid out?
Go ahead.
Mr. Chairman, Senator Ruffs, yes, exactly. It would need to be a conversation to outline this statutorily so it agrees with the streamlined sales tax agreement. Now, we already have the authority as a streamlined state to work on exemptions. The state of Wyoming can choose basically any exemptions that it wants. And so as long as we have those in the books and protect the vendors who are selling this equipment into our state from liability, then we have that ability to do it. The other way is the direct pay permit process. And this is also another avenue that allows the vendor to not charge sales tax, and we already have provision of those in our statutes. Both in statute right now, we reference the streamlined sales tax agreement, certificates of exemption, and direct pay permits. So it does take a little work with the language, but based on our conversations, we believe that's something that's possible.
Okay, good.
If I may, Mr. Chairman, just as a follow-up to that, you can see where the possibility or the concept of splitting these two concepts out, because the options that Mr. Fanning just mentioned related to sales and use tax would not specifically be tied to equipment, that's stored in a commercial storage facility. This is a conceptual change to how we source sales and use tax. But the property tax exemption that is afforded in this bill, that could be separate. You could have a property tax exemption if your desire is to provide tax relief for equipment that is stored in a commercial storage facility for economic incentive for the commercial storage facility, which is where that concept really started back in 2018, I believe, when we first saw this concept. And so it is possible that we could pursue this, but perhaps as two separate concepts.
Go ahead.
On the property tax exemption side, and I think we worked the math out a few different ways depending on what the bill form was. It started off smaller and this is expanded. But what's the fiscal impact at this point in time of this bill? This is similar to ones we've seen like last year and the year before. Do you have a sense of what the financial impact of exempting all of this inventory is for the state on an annual basis?
Director?
Mr. Chairman, Senator Rothfuss, I really don't, because currently, under Wyoming statute, if that company owns equipment, all they report to either the local county assessor or to the Department of Revenue is that it's an asset on the books. They do tell us where it's located in that Is it in Laramie County, or because if I have equipment, I'm a company that has equipment in multiple counties, I've got to report to each one of those local county assessors, unless it's a state assessed property that we're doing. But we don't know if they're situated in a commercial storage facility. But if you just go down the path of all equipment before first installed, I will tell you it is a significant amount if you just limited it to that. Because all of the companies across the state, they hold on, they keep spare parts. They want to make sure that they're not down any length of time. If I own a refinery, I have an entire storage building full of spare parts that are not installed yet, that they're paying property tax on currently.
And Mr. Chairman?
Go ahead.
And I think if this is being held over for the next meeting, if there's any way that we can get any sort of an estimate with whatever assumptions are needed, that would be useful, because I do have a sense that we're talking tens of millions of dollars of property taxes. You know, not just tens of millions of dollars of inventories, hundreds to billions of inventory and substantial property tax through this.
And Mr. Chairman, if there is a source, if anyone listening is a source of where commercial storage facilities exist in this state, that would be a starting point, because I don't know that.
That's a tough ask, Senator. Well, we're going to come back to Brian. And then, let me double check the committee first. Any further? Okay, I sense that Brian and you, Mr. Co-Chair, need to work together. Okay. Brian, are you good with that? Do you want to follow up on anything? Okay, let's do that. If there's no further questions for our committee, let's double check public comment in the room or on Zoom. There is one? Okay. Thank you, Director and colleagues. Oh, and one in the room. Work your way up here. Let's let you speak first, and then we'll go to Zoom.
Thank you, Mr. Chairman, members of the committee. Dixie Huxtable, Converse County Assessor. And I just wanted to reiterate a little bit of what the department was talking about and give you some examples of Converse County. We do have companies that have what they refer to as laydown yards, and they have their extra equipment sitting in those yards, and they report them every year, January 1st. Whatever the inventory is that's sitting in those yards that they're anticipating installing sometime in the near future. Every January 1st, that list changes. It can be hundreds of items, but that's what the company reports to us. And so the dollar amount can be $10,000 items, or it can be one $500,000 item. So the dollar amount that's in here is of particular interest to us because they're itemizing that individually, and that would be some detail that would be relevant to us when we get those returns. The equipment is located maybe in Converse County because that's the closest place they could put a yard, but that equipment may end up in Campbell County when they actually get it installed on a well. I don't know where that piece ended up. All I know is that next year when that rendition comes in, those items are crossed off. I look at my new wells when they render a new well, and it's got a new piece of equipment. Where that equipment came from, I don't know. That's a company, probably nightmare for them to track as much as it would be for us. So when we saw this bill, the assessors had some of the same concerns the department, the director just reiterated to you. One, we're presuming there's an application process. There would have to be some sort of an application process because we don't have commercial storage facilities that we're aware of. They're private yards that the companies own. Now, there very well is some commercial storage facilities across the state, but they're not identified that way to us. And certainly the department would need to know that. And again, January 1st is that magic date for us by statute. So whatever that company has purchased and has available on January 1st is what they report to us. There are some instances where I could give you some numbers for Converse County, but that's only in very limited cases where they've identified them as their yards with equipment. That in no way goes close to the refineries that Director Hinson was talking about that have, buildings filled with spare parts that they're going to use, that they've also included in our rendition. So I just wanted to reiterate what she had said, and we're happy to work with you in the future on this and try to clear it up so that we can all administer it fairly.
Thank you. Committee, questions for our assessor? Go ahead, Co-Chair.
Thank you, Mr. Chairman. So, Ms. Huxtable, did I hear you volunteer?
Mr. Co-Chair, yes, you did. I would be happy to help.
Thank you. Committee, anything else? All right, thank you. Assessors have to be tougher than county commissioners, right? Yeah, yeah. All right, online? Left? Okay, very good. All right. There she is. Okay, go ahead, whomever's there.
Hi, can you hear me?
We can't see you. Got a camera?
Oh, it's, wow, it's not engaged.
Well, go ahead and speak. So we keep
Okay,
moving forward. Thank you.
Let me try something here. Does that work? There we go. Thank you, Mr. Chairman. I just have some brief remarks. I would like some clarification first, though.
No,
To be sure I understand correctly.
Whoa, wait. The committee will ask the questions. Do you want to offer a brief remark and then move on?
Okay, I will word it that way.
Give us a brief remark, and then we'll leave the questions to the committee. Thank you. Go ahead. Identify yourself.
Okay, my name is Carrie Agan.
Thank you.
I understood,
Comment?
yes, I understood Co-Chair Burkhart to say that this tax is deferred rather than exempted.
Okay.
Deferrable is preferable to exemption, but this is still discriminatory against those businesses who can afford it least, which is the smaller businesses who own and purchase less equipment than larger businesses. This is
Okay.
essentially a penalty for having a smaller business and purchasing and storing a relatively small amount of equipment.
Thank you for your comment. Appreciate it. And we're going to keep moving forward because we have an afternoon full. Is that the main part of your comment?
Yes, I was just going to say one more thing, if that's all right. It's very quick.
Quick.
Okay, thank you, Chairman. So the state should be incentivizing small businesses, as these have been and still are the backbone of our country and our state. The profits from smaller businesses tend to stay in state rather than siphoned off out of state. So I urge the committee to kill this bill and any and all related existing statutes. Thank you.
Thank you for your comment. Okay. All right. This is what we're going to do. Absent any more comment from the room or on the line, the committee, we're going to have Co-Chair and Brian work this and bring it back in October. Is that agreeable with you, Mr. Co-Chair? Yes. Thank you. Mr. Senator, go ahead.
And for October, I think it's important for us to go through a why we would do this bill discussion again, because we've been talking about it for 7 years now. I have never been convinced that it's
Haven't got your why answered?
Yeah, still haven't gotten a positive why out of this bill in 7 years. We skipped it today, so in October, if we could understand how this would benefit anything to do with the state of Wyoming. I can see how it would benefit a county, like if you set up a yard in Casper, I could see how it would take resources from the rest of the state. I got that. So Natrona would do great and other places wouldn't, or whoever set it up. But I don't understand how it would be a net benefit to the people of the state of Wyoming. So if we could have that discussion next time.
Okay, Mr. Co-Chair, the answer to why next time. Thank you. Anything else? All right, folks, we're moving on. Authorization of sales and use tax, Brian, we throwing them at you too fast?
Yep, Mr. Chairman, 25 LSO 120, amortization of sales and use tax, draft 0.4, this is 5-03 in the online meeting materials. This is a bill draft the committee requested in May. It is based on 2021 Senate File 61 engrossed and would authorize the amortization of sales and use taxes for certain specified projects. So starting on page 2, line 6, if after July 1, 2025, any taxpayer develops a project to be completed in Wyoming that is reasonably anticipated to have expenditures that are subject to sales or use tax in Wyoming over the first 2 years of construction or operation in excess of $5 million, then the taxpayer can apply to the Department of Revenue to amortize the sales taxes. But only the portion, and these are the references on page 2, lines 13 and 14, you would only amortize the portion of sales tax that is collected and distributed to the general fund and the Department of Revenue for up to 10 years. Then on page 2, line 17, the department is required to establish amortization schedules, fees, terms, and conditions for each project that is approved for amortization. On line 20, interest rates must be established by the department to account for inflation. Page 2, line 22, the department is required to establish and publish at least once every year fixed terms, rates, and fees that are available for taxpayers for amortization. Page 3, line 3, the amortization agreement that a taxpayer in the department would reach must include a lien on the property of the project for which the taxes are amortized. Line 5, the lien that would be as part of the agreement is paramount and superior to any other lien or encumbrance created before or after. So in other words, this lien would be a first priority lien on the property for which the taxes are amortized. Page 3, line 7, a failure to pay under the amortization schedule subjects the taxpayer to all enforcement provisions that are available under this article of statute. Page 3, line 10 requires the Department of Revenue to adopt all rules necessary to administer this program, including requiring full payment of any outstanding amount of payments within 30 days if the taxpayer discontinues the business or discontinues the project. Page 3, line 15, if a taxpayer is approved for amortization, no vendor is liable for returns, reports, or payment of taxes related to that project. And then page 3, line 18 defines what a project is for purposes of the amortization. It means any land, building, other improvement, all real and personal property, including machinery, that creates employment opportunities within the state or that adds economic value to goods, services, or resources within the state. Then on page 4, beginning on line 7, in a new subsection in 3915-111, which concerns the distribution of sales taxes, this new subsection provides that revenues for the amortized payments that are recognized as revenue during the fiscal year that payments are made for accounting purposes, and then those payments are distributed just as sales tax otherwise would be. Then page 4, line 19, similar concept for use tax, for how those payments are scheduled and accounted for and then distributed. With that, Mr. Chairman, I'd stand for questions.
Questions of Brian? Let's go to either co-chair or Senator Rothfuss. You were part of this, bringing this all together, either one of you?
Thank you, Mr. Chairman. Mr. Chairman,
Your mic?
yeah, Co-Chairman and I worked on this a few years ago, and there was a lot of interest in this approach by industry. There were some challenges that led to it not coming forward. A lot of those challenges have been addressed through additional drafting. The idea being that the cash flow, rather than financing as a means of paying for the sales and use tax, can be financially beneficial to the industry without having any financial cost to the state. So it's basically a no-cost benefit option for industry. And again, there was a lot of interest in it. Some of the challenges that were raised, and I think are still here, one is there was interest of using all taxes. As Mr. Fuller noted, this is only the state's portion of taxes as written, and it adds a lot of complexity to bring in decision-making over local and county taxes. That could be done, but this doesn't do that yet. And one of the thoughts would be to, start with at least the state share, which is relatively straightforward. And then if this is successful, potentially move on to provide a mechanism for local options amortization. The other aspect where there was a concern raised had to do with the amortization agreement being a superior lien, and the possibility that would cause some concerns for credit, and a desire by some to have alternative surety instruments that would be potentially equivalent. That language could be added, but something that would provide the same level of guarantee but wouldn't affect the credit side of things and their interactions with banking. That's not in here, so that would be something that could be added for the next meeting. We could work through some additional language in that. And the only other discussion really centered more around the appropriate size of projects. This requires about $5 million anticipated of tax payments in the first 2 years. There's nothing magic about that number. And you think about that, that's a pretty significant sized project if you have $5 million of sales and use tax over 2 years, you're talking it's a project on the order of $100 million plus to be getting to that point. Nothing magic about that, but part of the concern originally, and the department can speak to this, was the additional logistical concerns of carrying this out. So there was some desire when it was drafted and discussed to ensure that it was a relatively small number of projects because it would be some work for the department. And so trying to keep the number of projects down to a reasonable workload for the department, certainly in the early days, was the impetus for that number, and it may not be perfect. So that's a little bit of background on it, Mr. Chairman.
Thank you. Mr. Co-Chair, would you like to add anything?
Mr. Chairman, no. Senator Rothfuss captured it all. We've worked on this for a number of years, kind of worked on all the negatives to it, and I think we've resolved most of those. And the idea, again, was to help companies coming in with cash flow. If you look at some projects that are coming into the state right now, they could be spending $1 billion upfront on equipment, and at 4%, you can do the math, $40 million that they have to come up with immediately. This gives them the opportunity to amortize that over a period of 10 years and help their cash flow, maybe make the project a little more palatable to bring it to Wyoming. I can foresee some of the data centers that are coming in that range. Some of them are actually going to need another power plant just to power the data center. So this helps them make those decisions, and that was the whole concept.
Okay, committee, anything further? There being none. Any public comment in the room? Any public comment online? Okay, oh, we do have someone. Go ahead. Department of Revenue, welcome back.
Thank you, Mr. Chairman. Again, Brett Fanning, Department of Revenue. And just summarizing up some of the topics that we talked about, I'll try and be brief. I'm not sure we can administer this as the way it's currently written. I know there's been some updates over the years. There's kind of two main points for us, and it still gets back to our earlier conversation about how do the vendors know not to charge the tax? And this is that concept where we've got someone who's bought a big piece of equipment, big piece of machinery, a big load of materials. The vendor's got to know not to charge the sales tax. And so how do we navigate that? That's one of the main considerations here, because the vendor has got to charge the sales tax unless they're told otherwise. And I've kind of just gone over the two logistical items that creates. It's an exemption certificate or some sort of a direct pay permit. So the vendor's going to charge sales tax unless they're told otherwise. But that's the intent here, is for the vendor to not charge the sales tax. It piggybacks into Senator Roth's point about this is only the state portion of it. That creates a streamlined sales tax compliance issue with us, because now you've got a vendor who's only charging a portion of a rate. And that's very difficult to navigate in streamlined sales tax complexities. Not sure how we're going to navigate just the state portion of it. So like when we went to lunch today, we paid our 5% here in Natrona County. Are we telling now a vendor who's going to not pay tax, they've only got to pay 1%? And I'm using a restaurant example, but you can kind of see how that plays into it. It also goes into something that Director Henson and I were brainstorming about is we're talking about a 10-year time period. In Laramie County, we've had several different tax rate changes there. And so how do you amortize that over 10 years if you're bouncing between 6% and 5% and 6% and 5%? How do you navigate that? Generally, it's based upon the invoice date, and that would be when the tax is due. But then when the tax actually comes into our department, and our administrative services does an excellent job of getting it back out to our local partners and to the state, how does she account for that when it's coming in 10 years down the road, when that specific purpose or that general purpose is no longer in motion, but tax was collected on that on its initial purchase? So just still some complexities here. The department is obviously willing to help moving forward with this one, but it's really tough for the department to administer, not necessarily for us and having to do some of the paperwork on amortizing this. We're used to doing that. We do payment plans all the time, similar concept, but not exactly. The tax has already been paid. Here, we're trying to not make the tax paid and then pay it over a certain amount of time. So that is a little different, but we're used to doing those schedules. We certainly do. With that, Mr. Chairman, I think those are all my notes, and I'll stand for any questions.
Committee questions of the department. Here we go. Brett, Senator.
Thank you, Mr. Chairman. One thing that was discussed, and sorry, I forgot, that point was one that we did discuss, and it's a good one about whether to not collect the taxes, which is a challenge, or whether to do effectively a rebate of those taxes collected where you demonstrate this $50 million worth of sales and use tax was collected for this project. We want to schedule an amortization of that, so it would basically be a rebate and schedule at that point. It sounds like that's something that you'd be more prepared for. That would work within the current system, even if it's not perfect or optimal, that's closer to something that you could do now. Is that accurate?
Go ahead.
Mr. Chairman, Senator Rouse, yes, absolutely. That is something we do, because then we have the tax in hand.
Yeah.
And then I remember some discussions years ago, maybe the department had a certain amount of time to make sure that tax got back to the actual taxpayer. So then they can fund these cash flow issues that we've been discussing. Yes, there would be some IT programming involved, but certainly something that the department would be much more prepared to tackle right away.
Thank you.
And
Good there.
Mr. Chairman, one follow-up on that, and we can work on this for next time, but maybe some language that allows you to do it either way, I think would be the key, because it's suboptimal to have the rebate, but it's still a lot better than not having the program. So getting to the point where maybe we could move to an understanding of avoiding the taxes at some point if we can figure that out, but getting to where the statute makes it clear that you could do a rebate type approach where the taxes are paid up front and then the rebate goes into place, that flexibility, if you could help us with that language. Thank you, Mr. Chairman.
Go ahead.
Mr. Chairman, Senator, yes, we'd be happy to help.
So let's do this. Senator Rothfuss, you're talking about carrying it down. I wonder if we should put it up and actually get it moved forward with an amendment now. Are you ready for that? I think my co-chair was jumping forward in his seat. Okay, go ahead.
Thank you, Mr. Chairman. I did have some questions for Mr. Fanning.
Oh, go ahead then.
Okay, so, Mr. Fanning, we've had this discussion before, and I forget the number. How many companies do we have on direct pay permits?
Yep, Mr. Chairman, Mr. Co-Chairman, it's 24 as of last count. And that's only 24 out of our 50,000 licenses. In our rules, the direct pay permits they're not stringent, but they're really geared towards bigger companies. You've got to make $5 million or more in taxable purchases a year to qualify for this direct pay permit. As you can imagine, it's a lot of our bigger companies, pipelines, oil field companies, those are the big ones. There are others, but those are the primary big ones.
Just a follow-up, quick follow-up. So, Mr. Fanning, would it work better, cleaner, smoother if this was limited to only those companies on direct pay permits?
Go ahead, sir.
Mr. Chairman, Mr. Co-Chairman, yes, there is no doubt. The reason why logistically is because direct pay permit holders, they give an exemption certificate out to everyone saying, hey, don't charge me tax, I'm gonna take care of it myself. And then if you have those 24 companies, then they correspond with the Department of Revenue and say, hey, I'm gonna amortize it for these ones. Then we can tackle that and navigate those issues. The downside with that one is you've got 24 companies. There are other companies that would qualify, but for a variety of business reasons, they decided not to get a direct pay permit with us. They don't have to, that's just an option.
Thank you. Good?
I'm good.
So, Mr. Chairman, that perhaps then, again, getting this language right to move this on, if it were either they have a direct pay permit or you do a rebate style instead of pre-tax. Sounds like that then works as something that's logistically feasible. Is that accurate?
Mr. Chairman, Senator, yes, that is something that's feasible. Yep, that toggle, because then the vendor is protected, they don't have to charge the sales tax, and then if they do, then we get it back to the taxpayer as soon as possible or per this committee.
Thank you.
All right, nothing else, and we've taken comment from the room. Committee, anything else for the department? No. So we have the opportunity, actually, to the two people who've worked on this the most, to possibly move it forward from here. Senator Rothfuss, do you think you could make those changes if we move this bill?
Mr. Chairman, if we wanted to have just a little bit of flexibility and have a conceptual amendment where we require that the entity be a direct pay certificate holder or whatever the term of art is, or that the department may work through collection and rebate, and then
Keep that in mind.
work with Mr. Fuller on that.
Yeah, we can do that. Let's see if we got a motion then. Are you good, sir?
I don't know if we
Anything
have
else?
any public
Did you want to offer anything?
Mr. Chairman, if, Mr. Senator, that direct pay permit language in our sales tax statutes is 3915-107.1. Yes, it is a .1 there.
Goes right to it.
Thank you, Mr. Chairman.
That's why you folks are in revenue. Okay, let's, go ahead.
Mr. Chairman, I understand where we are, and I think we need to work through an amendment rather than try to do this one on a fly.
Okay, are you, so you're both comfortable sitting on it?
Yeah.
Okay.
Yeah.
More work for October, Ryan?
Yeah.
Okay. We're not going to entertain a motion then. We're going to carry this over to October. Thank you to the department. Good reports. Okay, committee, let's go straight to Integrated Test Center governance. After Brian catches his breath. Go ahead, Brian, present.
Yep. Mr. Chairman, members of the committee, 25 LSO 45 draft 0.5. This is Integrated Test Center Governance 6-02 on the meeting materials. This is a bill draft the committee requested in May. It is based on 2024 House Bill 215 and would codify and continue the Integrated Test Center that was initially created in the 2024 budget bill in a section 300 of that bill, and would transfer the center's oversight and operation to the School of Energy Resources. The bill would specify the governance, budget procedures, and reporting requirements for the ITC. The key difference between this bill draft and last year's House bill is that in this bill draft, the transfer would take place the same year it's enacted. So House Bill 215 last year would have given an extra year to study that before the transfer took place. As this is drafted, the transfer would take place on July 1, 2025, when the bill is effective. So page 2, line 2, this is a non-codified section and just specifies that the Integrated Test Center shall be transferred to the School of Energy Resources on July 1, 2025, and except as provided later in the bill draft, which I'll describe, all property, equipment, obligations, and unexpended funds of the test center shall be transferred to the School of Energy Resources on July 1, 2025. Page 2, line 13 would require the director of the School of Energy Resources to prepare a plan by May 1 for the transfer of the test center and its programs, assets, obligations, and functions to SER. And the director would be required to submit that plan to this committee upon completion. Then, not later than October 1, 2025 and February 1, 2026, the School of Energy Resources and Integrated Test Center would report to this committee on the status of that transfer and recommend any legislation necessary to correct or improve the outcome of any issue that's identified in the codification and transfer of the Integrated Test Center. Then page 3, line 10, beginning with the effective date of the subsection, which would be immediately upon enactment until July 1, 2025, the Integrated Test Center must consult with the School of Energy Resources, the Energy Resources Council, and the governor regarding any agreement, contract, lease, or other obligation that the Integrated Test Center seeks to enter into on behalf of the center. Page 4 is a new section of statute that would go right after the statute concerning the School of Energy Resources in Title 21. And it just says, so page 4, line 1, just specifies that the Integrated Test Center is codified and continued. The School of Energy Resources, under direction from the Energy Resources Council, would oversee and operate the center. The School of Energy Resources is page 4, line 11, would establish the structure and policies for the operation of the center consistent with the objectives of this section and 21-17-117, which concerns the School of Energy Resources, and shall engage as many academic departments and colleges as possible in support of the center. Page 4, line 19 specifies what the School of Energy Resources must do in operating the center. So first, design, construct, and operate a research facility. This is language from the 2014 budget bill and says that the Integrated Test Center constructed under the budget bill qualifies and satisfies this paragraph. Page 5, line 8, provide a testing location for research projects. Page 5, line 12 concerns leases, and this is another place where a minor change has been made, primarily based on discussion in May. So first, the School of Energy Resources would be required to enter into leases with owners of real property where the research facility is located, and would require a right of first refusal for that owner to purchase the research facility and all fixtures at fair market value upon conclusion of all of the center's activities. Then page 6, line 1, would require the school to enter into leases with persons and entities who wish to perform research or other projects at the facility. Page 6, line 7 requires the establishment of relationships and work with the governor, the Energy Authority, and any other relevant entity or state agency to ensure coordination of the center's activities. Require the School of Energy Resources to prioritize research space at the facility to research projects that the School of Energy Resources and the Energy Resources Council determine would have a high likelihood for commercial success, increase the knowledge base within the state of Wyoming on CCUS technology, and increase the national and international exposure of the state of Wyoming. Most of this language in this paragraph, Mr. Chairman, comes from the 2014 language. Then page 7, line 10, prioritize projects that add ancillary or supplemental value to Wyoming products or byproducts, or lead to the development of methods or products that may advance the future use of Wyoming's natural resources. Page 7, line 17, requires the School of Energy Resources to establish and collect fees and prepare a schedule of fees, rentals, and other charges for use of the center. Page 8, line 1, would provide that any fees charged or collected would be deposited into a newly created Integrated Test Center account. Funds would be invested by the state treasurer in accordance with law, earnings deposited in the account, and then funds would only be expended upon legislative appropriation for the Integrated Test Center. The staff comment on page 8 just notes that the committee may wish to consider whether a new account is necessary here, or if this is something that the School of Energy Resources could account for and manage with, just as they do for other research projects and programs. Page 8, line 24 is an annual reporting requirement where the SER would have to report to this committee and Joint Appropriations Committee on the center's work in the past fiscal year, the center's accomplishments and the benefits that accrue to Wyoming's economy, the current occupancy of the center, and the amount of fees and charges that are collected by the Integrated Test Center and the balance of that Integrated Test Center account. Page 10, lines 11 to 14, this is amendment to current statute and would require SER to include in the budget that it submits a budget for the Integrated Test Center. Page 10, line 21 is just language that requires SER to oversee and manage the ITC. Page 11, line 3 is a non-codified section that just provides that on July 1, 2025, the Integrated Test Center is transferred to the authority of SER. All property, equipment, and unexpended funds and obligations associated with the test center, including any unexpended funds that remain from that 2014 budget bill, would be transferred to SER. Any funds that are appropriated to or for purposes of the Integrated Test Center in the 2025 general session would be transferred on July 1, 2025 as well to SER. Page 11, line 22 just provides that nothing in the act is construed shall be construed to impair any existing agreements, contracts, or other obligations of the ITC that were entered into the by the Integrated Test Center or on the ITC's behalf before July 1, 2025. And except as otherwise provided in the subsection, those agreements, contracts, or other obligations entered into by the ITC itself or on the ITC's behalf shall be treated as if entered by the SER. SER must, to the greatest extent authorized by law and upon assuming responsibility for the ITC, must fulfill those existing obligations. For any, and this is page 12, line 13, for any existing agreement, contract, or other obligation that for whatever reason SER is unable to assume lawfully, the entity or agency that originally entered into, assumed, or holding that contract or agreement shall retain and fulfill those obligations. Page 12, line 20, a similar concept except for appropriated funds. If any funds appropriated cannot be lawfully transferred to SER, the entity or agency to whom those funds were appropriated retains those funds and expends them in accordance with the terms of that specific appropriation. And then a split effective date, it would be effective July 1, 2025, except subsections 1B through E. So those were the non-codified sections on pages 2 and 3 would be effective immediately. With that, Mr. Chairman, I stand for questions.
Any questions for Brian? No, go ahead. Senator, let's go Representative and then to you. Yeah.
Thank you, Mr. Chairman. Question, Ryan, on page 8, line 24. Does that impede us if our meeting is after October 1st with the current language?
Go ahead, Brian.
Yeah, Mr. Chairman, Representative Conrad, so your question is, would this impact the committee having that as October 1st? Mr. Chairman, I think the intent here by setting it October 1st, historically, the third meeting of this committee has been after that date, to where that the committee, in essence, would receive the report before the committee meets for a third time.
Great, thank you.
Conrad, good. Okay, Co-Chair, go to Representative Lawley and then we'll come back to Co-Chair. You didn't? Okay, we're back to you, Co-Chair.
Mr. Chairman.
Oh, go ahead, Senator.
Thank you, Mr. Chairman. Just one more time. I think Brian said it already, but I just want to make sure I heard it. The language that's used, like it's twice in the bill, but the increase the knowledge base within the state of Wyoming on the capture, sequestration, utilization, and management of carbon dioxide emissions or other emissions with a potential benefit. That whole language, remind me where you said you got that from?
Yeah,
Brian?
Mr. Chairman, Senator Ellis, that's from the 2014 budget bill, from that section. I don't recall the exact number. I think it's 314 is where that's from.
Okay, thank you. Co-Chair.
So, thank you, Mr. Chairman. Brian, a quick explanation, and I asked you this question earlier, like last week or the week before. Why do we need a bill this big to transfer ITC over to the SER rather than just saying, here, handle it, and we'll give you a bill that handles contracts?
Brian?
Yep, Mr. Chairman, Chairman Burkhart, I think a couple of reasons. First, this was established in a budget bill, which typically those bills are bills that are in effect for 2 years for the period of that fiscal biennium. So that would be, I think, one reason to codify that language in statute if it's intended to exist, for a period of time beyond the period of the budget. The second, I think the second point maybe to note would be, past actions of the year, past reports from the Integrated Test Center, may lend itself to a question of, clarity for, who is operating this center. And this bill, I think, clearly answers that. The final point I would make, Mr. Chairman, in terms of, why this bill, why a lengthy bill, is to address those contracts and appropriations that have already been entered into. And Mr. Chairman, I can't really speak to, the nature or entities of those contracts. The language in this bill is intended to cover that if they can be transferred lawfully, they would be to SER on July 1st, 2025. If not, those contracts, those appropriations would remain with the entity that either made the contracts or received the appropriations.
Co-Chair? Good. Anything else from the committee? All right. Dr. Krukta, we're about ready to add to your workload. How do you feel about that?
Mr. Chairman and members of the committee, I'm Holly Krukka, Executive Director of the School of Energy Resources. I believe it was March 9th, 2023, that the governor wrote a letter of delegation asking the School of Energy Resources to lead administration of the Integrated Test Center. And at that time, we began the transfer process of all the contracts. We already have the funding. The original funding for the Integrated Test Center is now at the University of Wyoming. So many of the things covered in this bill have already happened. And our main issue is that we are currently, we being the University of Wyoming and the School of Energy Resources, are not able to administer the leases with the tenants of the Integrated Test Center or the lease with Basin Electric. So that is our final hangup. So that's the main thing that we need covered, but we've been having that extra workload, Mr. Chairman, for over a year now.
Easy to do then. Committee for Dr. Krukta, and then we'll let her defer to whichever person she would like to.
Mr. Chairman?
Go ahead.
So,
Representative Hawley, go ahead.
Thank you, Mr. Chairman. Do you feel like this bill answers those questions and those issues where there were kind of some hangups and different kind of issues in play? Do you think this clarifies that enough for it to deal with the issues you mentioned that were still in play?
Dr. Krukta.
Mr. Chairman, Representative Lawley, I think that it does. There are some parts of the bill that introduce new questions on my side, at least.
Representative Good?
Yeah, I follow up on that.
Go ahead.
So is it your understanding that under the bill, that after a certain date, say, for example, some of the leases you mentioned, after they expire, you are in a different position under your authority under the bill than you are while they're in play?
Dr.
In other
Krukta?
words, once they're over, do you have authority to on the leasing side of the center?
Go ahead.
Mr. Chairman, Representative Lawley, without any change, we are not in a different place. We have transferred all the other contracts. It is truly the leases that are causing the issue.
Okay.
Okay, thank you.
I would just say,
ahead.
Mr. Chairman, thank you. I would love to hear your thoughts on what new issues are created at the right time.
Okay. You have a question, Co-Chair? Go ahead.
Dr. Krukka, I'm on page 8, paragraph F, just if you want to refer to that. It requires a integrated test center account. Do you need a separate account? I'm familiar with how you account for all of the projects, all of the monies. Do we need a separate integrated test center account with everything that goes with keeping that account and then the report separate? Or would it be better to combine this with all the other things SER does?
Dr. Krukta.
Mr. Chairman, Representative Burkhart, I want to be clear, we would not combine it, but the University of Wyoming has more than tools in its disposal than it needs to make sure that the funds are kept separately. So for reference, an integrated test center is about $1 million per year spend project. It wouldn't be on one of our largest or most complicated projects by any stretch of the imagination, and we are able to administer those projects just fine. So we don't need a separate account.
Okay, nothing else from the committee. Dr. Krukta, which one of your colleagues next, in-house or governor's office?
Mr. Chairman, of course, I defer to Mr. Luthi from the governor's office.
Governor's office, Mr. Luthi.
Thank you, Mr. Chairman. Randall Luthi, Policy Director for Governor Gordon. First of all, I wanted to thank the members of the committee for willing to look at this issue. It's not a new issue to many of you, not a particularly new issue to me as well. The ITC was created in 2014. It was given to the governor's office. Frankly, the governor's office has always delegated most of its duties on the ITC to another entity, rather that be the infrastructure authority and then the WA. And now what we think is just a natural maturation of a growing up of the center now to SER. My concerns, well, actually, Mr. Chairman, if I've listened this afternoon, I've heard you lay back several bills, and I'm going to recommend that you do the very same thing for this one, because we think it does introduce some new concepts, some areas that we think that we would like to spend some time talking about. I understand clearly the question about, well, if it was in the budget bill, does it truly exist? I can tell you that last time I was in Gillette, it does truly exist, and it is still operating, and I don't know if we need to put that in the green books or not. But I would like the opportunity to actually talk to the AG's office as well and get their thoughts and feelings. If so, absolutely. And frankly, members of the committee, I think this bill does a lot more than what we were looking for. Right now on the leases and only the leases, it works out that our office drafts the leases, does most of the negotiation with the lessees, and then we send it over to the University of Wyoming, and they review the lease as well. So it takes a longer period of time. We think that at least part of this bill takes care of that issue. I struggle to find somewhat of an analogy, but here's what I came up with. I think we were asking for a Ford. We got a Ferrari, and I fear that we may have also got an electric Edsel. So we would actually like some time to work this through. And members of the committee, I would commit to you to work with SER, LSO, if you give us the authority to do so, to be ready to roll on this on your October meeting.
Thank you, Mr. Luthi. What exactly would you want to clarify with the AG's office, whether we can venture down this road?
Thank you, Mr. Chairman. I would just want to have a conversation with them on the necessity to codify language which is, in a budget bill. It isn't always done. I just want to clarify it.
Fair enough. Committee for Mr. Luthi. Committee? Okay. Thank you, Randall. Go ahead.
Mr. Chairman, I have nothing to add.
Okay, we're just checking, as long as you're at the table.
Thank you.
Thank you. All right. Let's go to comment in the room.
And Mr. Chairman, real quick, just to correct one statement I made, I think I said section 314 of that budget bill, it's 334.
Okay, I'll let that stand for the record. Thank you, Brian. All right, comments in the room? Comments on Zoom? Okay, you've heard the request, committee, to lay this back. They're going to do a little more groundwork. Committee, your thoughts on any of this before we say lay back? Representative Lawley?
Thank you, Mr. Chairman. I see this two levels there's levels of complexity here. There's levels of just the normal law of transferring ownership and agency and ability to act, liability that you just do in corporate transaction. That's at play here. Then you have the limitations of different functions of government and other things that may be slowing up or tripping up something that we have to deal with. And it is complex, and I think we want to get it right. I think we all want the same thing, which for this to be transferred and to be have a comprehensive control of the operation and running it, since you have all the obligations of it and the School of Energy Resources. So I do like the suggestion of letting them work with LSO and looking at different things. We can pull in what we might need from that section of the budget bill, but we are in no way obligated, in my mind, to take it wholesale. I mean, we can take parts of it we feel are needed to shore up any understanding about existence. Is it really, proof of life, whatever we want to call that? But so I think that it could be done a little bit better to meet these levels of complexity in a way that actually accomplishes the problems, addresses the problem. So I like that idea of them working that out, because they understand, the governor's office and the School of Energy Resources, the level of some of these complexities and maybe some creative solutions. So that's what we ultimately want.
Agreed.
That's what
I agree that we have the group here. I have more confidence in this group to let this place become what it's destined to be. And I believe we're missing the opportunity to get much more accomplished at the ITC. Anything else, committee? All right. Okay. October's the day. Okay, thank you. Thank you. Oh, co-chair?
Mr. Chairman, could I digress a little bit?
Well, you need them at the table?
With the School of Energy Resources.
Okay, go ahead.
So totally different subject. Where do we stand
Ready,
with,
here comes one.
where do we stand with MTR and their project?
Just for the record, in the public, PR, the acronym.
That's the company name, and they have a project using membrane technology at the Integrated Test Center that has a lot of promise for carbon capture.
Okay.
Mr. Chairman, Mr. Co-Chairman, MTR stands for Membrane Technology Research. They're one of the many vendors testing at the Integrated Test Center, or actually they're under construction today. They are building a 10 megawatt membrane-based CO2 capture pilot. It's called a large-scale pilot. So it's under by to directly answer your question, and they are scheduled to begin operating by fourth quarter of 2024, like the calendar year. And so they're under construction, and I would welcome anyone to come see the ITC or any of the projects that are being led by the School of Energy Resources. MTR's technology is really interesting because it's at 10 megawatts, maybe an average coal-fired power plant would be about a 500 megawatt plant, but because this system is completely modular, this is the last step needed before they could offer a commercial scale project to the commercial sector. So it's a very exciting project, but I would say the technology is very simple. It all depends, their success depends on if the membrane can last, if it accomplishes the separations it needs, and if it lasts long enough to make the technology economic. It's exciting for this part of the world because it doesn't require any water. Unlike some other technologies, it's a simple separation process. So
I know you said the year, but the fourth quarter of what year again?
2024, this year.
Oh, it's okay.
Yeah.
You picked that up pretty fast as he just threw that out there. Okay, good, thank you.
Yep, thank you.
Okay, one more time, thank you.
Yeah.
I think, Mr. Luthi, we need you at the table next, so don't look for it. All right, anything else, folks? Okay, we're going to move into, go ahead. My co-chair is suggesting if you wanted to offer a presentation after Mr. Luthi on anything. He's full of surprises today, so.
Well, Mr. Chairman, it actually was not a surprise. What would be a surprise if we didn't do a presentation? We actually put one together for you, but it just depends on the pleasure of the committee. So whatever works for you.
Let's have you come back. Let's let Mr. Luthi tell us how we're going to get lawyered up here, and then we're going to come back to SCR. It's all yours, gentlemen, whomever would like to speak.
Mr. Chairman, members of the committee, Randall Luthi, Policy Director for Governor Gordon. We accepted your kind invitation, which is one way to put it, to come and meet before the committee. I believe you already have the materials of the latest case list that we have. It looks like this. Uh-oh, I'm getting the old no stuff. Well, I will then turn to my counsel.
Track it down later.
Yeah,
Let's let you speak.
and I'd like to introduce you all to David DeWald of the Attorney General's Office. He handles many of the natural resource cases. It's my understanding we're here to answer your questions, or wherever you would like to direct us, I will attempt to answer. And when I can't, you can bet that Mr. DeWald will be able to answer. How's that?
Joel. So where do you work out of, sir?
I'm David DeWald with the Wyoming Attorney General's Office. I work in our Water and Natural Resource Division.
Go ahead.
My understanding is I'm here to answer questions today related to our energy litigation that we have pending. My apologies rather for failing to circulate our case list to you. That's a public document that we have circulated recently to other legislative committees. I'd say right now that we have approximately 24 federal natural resource cases that we have filed against various federal agencies for exceeding their authority and that might be EPA, it might be OSM, it might be BLM, but all things that have a nexus to federal natural resource work.
May I interject for just a second? Co-Chair, you wanted to mention something to that?
Yes, Mr. Chairman, thank you. The reason you don't have Mr. DeWald's presentation, and I just forwarded it to Heather to print for us, is that it's been a hectic last few days. Mr. DeWald sent it to me. He and I have played telephone tag.
So it'll all be matter of
we'll
public
get it
record, and
taken
we can
care
work
of here
with Brian.
shortly.
Thank you.
And-
Continue on.
And Mr. Chairman, I do have 14 hard copies. If you'd like me to distribute those, I could.
Staff can take care of that.
Thank you. Carry on. Thank you for bringing those copies.
So again, Mr. Chairman, some of the work that our division does in the Wyoming Attorney General's office includes what we call our HB 300 program, which is a legislatively funded program where we address federal natural resource issues. We have approximately 58 cases pending right now. And for each one of those, we have sought approval from the governor to fund various litigation. And sometimes that's in support of federal agencies. Sometimes it is against federal agencies. But that's the list that's being distributed to you right now.
Thank you. Anything further?
No, thank you.
Okay. Mr. Luthi, anything further?
Maybe just a little bit of clarification, Mr. Chairman. There's largely two sources of funding that comes through the governor's office. The Federal Natural Resources Policy Account, which the legislature established many years ago. That funds probably most of the natural resource litigation. And then Mr. DeWald also mentioned the coal litigation money, which you all provided in the last 4 years, specifically dedicated towards the preservation of the coal markets.
Good. Committee, you clear on that? Good information coming out here. Go ahead, Co-Chair.
Thank you, Mr. Chairman. Mr. DeWald, a question on your spreadsheet here. If Wyoming is not listed as the first state or first entity on this, that means we're a participant, correct? And if we are listed first, then Wyoming is taking the lead. Am I correct?
Go ahead.
Mr. Chairman, Mr. Co-Chairman, that's correct generally. For any case that has another state listed first on that list, we would be bringing suit on behalf of the state of Wyoming in a state coalition case.
Okay. So follow up to that, Mr. Chairman. So, Mr. DeWald, all of these are the current pending cases. Am I correct? I just want to make sure I know what I'm reading.
Mr. Chairman, Mr. Co-Chairman, that is correct. Generally, you can see there are a couple of older cases on here that frankly could probably be removed right now. We've got like our regional Hayes case on page 1. That was a victory for the state of Wyoming last year, and we have since passed any appellate deadlines. So that one is basically over, and on page 2, we've got our ozone transport case. In that case, we have voluntarily dismissed after EPA agreed to fulfill their duties to review our state implementation plan in that matter. So those 3 could probably be removed, but otherwise, yes, these are all active cases.
Okay, thank you. Committee, go ahead.
Mr. Chairman, can you repeat the 3 that are no longer applicable?
Yes, Mr. Chairman, Representative Conrad, Wyoming v. EPA, Regional Hayes on page 1. PRBRC v. EPA on page 1. And on page 2, Wyoming v. EPA ozone transport, the second from the top on page 2.
Good. Oh, 2. Let's back up to, go ahead, Representative.
Thank you, Mr. Chairman. Just to follow up, can you walk us through, I know we approved as a legislative body money towards, obviously, your efforts. What is the processes that you determine whether to engage or not engage, or litigate or not litigate?
Go ahead.
Sure. Mr. Chairman, Representative, generally, these are decisions made by the Attorney General in consultation with the governor. And so that would be our process, is that we might provide a recommendation, but ultimately it is at the direction of the Attorney General.
Conrad, Conrad, good.
No, I apologize, Mr. Chairman, just to follow up. So the Attorney General is really the one who promotes recommendations in collaboration with the governor's office for issues that you should litigate.
Mr. Chairman, Mr. Representative, that's correct.
So, Mr. Chairman, so we as legislators, if there's an issue that we feel strongly about as a legislative body, our influences should be directed towards the Attorney General in terms of litigating issues at the federal government's level?
Go ahead.
Mr. Chairman, Mr. Representative, I think it might be a better process to consult with the governor's office, because ultimately the governor's office is the one that approves the funding through the FNRPA account.
Thanks for clarification.
Representative Lawley and then Representative Heiner.
Kind of along this similar vein, I just would appreciate you providing a little bit of background for the committee about the processes and some of the issues involved as you look at particular issue and you look at jurisdiction. You look, for example, you look at strategically if you're going to join a group and what do you look at there, not again in a level of detail with each case, but generally that there is an extensive process that is folded into it, a lot of strategy about ultimate goals and ultimate success. It kind of helped them understand that, because I think there's a lot of public misunderstanding about that. They kind of have the, in my view, ambulance chaser idea of somebody got hurt, so let's file something, and the complexities of some of these cases and to ultimately win them, which is, I believe, part of the calculation and advice the Attorney General ultimately provides to the governor. Could you give a little bit of background of sense of how that works, and sometimes the time it can take to coordinate those, even to the level of if your name is first, what are the responsibilities? And if you're in a coalition, how to, each coalition might look a little different in terms of who pays for what, how decisions are made within that group. And all that's negotiated in advance typically. So I just love you to educate about that, because it's questions I get a lot, and there's a lot of misunderstanding about that.
Sir?
Thank you. Mr. Chairman, Representative Lawley, I can talk just generally about the process, right? If we're talking about a regulation that has been promulgated by EPA, for example, the process begins all the way back in the rulemaking steps. And so really at that point, when we identify in the Federal Register a proposed rule that we think will negatively impact Wyoming in a myriad of ways, whether it be our energy resources, minerals, anything else that we think has an impact on Wyoming, state agencies are generally directed to comment on those federal rules. And that's kind of what kicks off our process, is a general review of those comments to make sure that we're going to preserve the state of Wyoming standing to address those rules in future potential litigation if we determine that those rules are adverse to the state's interests. And so we'll go through that process, and rulemaking is certainly, in some respects, kind of lengthy. So we'll start with the Federal Register notice. We'll have agencies that comment on those rules. We'll follow the rulemaking process, and then ultimately the federal agency will promulgate the final rule that enters the Federal Register. At that point, there's kind of a collaborative process between the Attorney General's office and the Governor's office. And I won't get into the back and forth on the details of all of that. Some of that is, I'd like to retain our privileged and confidential kind of process. But I can say generally that we consult with the Governor's office all along that way to make sure that we're dotting our I's and crossing our T's with respect to preserving the state's right to sue on a final rule. At that point, sometimes there are multi-state coalitions that are interested in pursuing the same rule with respect to challenging it, and there are jurisdictional issues that feed into that. And so, for example, under the Clean Air Act, a lot of these rules have to be litigated directly in the DC Circuit Court of Appeals. So that's a very unusual process. We don't go straight to a federal district court with respect to Clean Air Act rules, such as many of the ones that are on this list. We have to go directly to the DC Circuit Court of Appeals, which is essentially the court that resolves those issues. And there's a lot of calculus that goes into whether or not we join a suit or bring a suit on our own. I can tell you that generally, since it has to be in the same forum, though, it makes a lot of sense for us to join some of our sister states to litigate these rules as a coalition effort, because it's going to be in the same court. A lot of times, multiple challenges get consolidated before that court anyway. And many on this list we'll have, you'll see on here under the docket number, you'll see a lead case. And sometimes right now with respect to Clean Air Act litigation that we have pending, you might have a dozen or more cases all consolidated before the same panel in the DC circuit. So that was a very long-winded way to kind of give you the general process, but that's at least for the federal rulemaking process. There are obviously other types of cases that are on this sheet, including Endangered Species Act cases. Those go a different way than the rulemaking, but that at least maybe gives you a little bit of an overview of the rulemaking challenge process.
Good. Go and follow up.
Thank you, Mr. Chairman. Thank you for that. It was a good, I think, background that, again, when you don't know, it seems very simple. And the more you understand, the more you can see why some things may take some time, especially to get the right outcome. And so I really appreciate you filling in there. One point that I think you were making there, but I want to, again, have you address specifically, is there are often in many of these cases a requirement that you exhaust administrative remedies before you can file a suit in federal court. And sometimes people get mixed up there too. They don't understand that you don't get to determine when that last determination of the administrative process is done. You have to wait for that process to work out. And by law, you don't have the right to sue jurisdictionally until you've exhausted that remedy. And just if you could expand a little bit on that, I just want citizens to understand the timing and the skill it takes to do this well. And these issues in Wyoming are important enough to do them right through these administrative processes, to not give up rights, to hold on to standing, and to exhaust these processes so that when we go to court, we have the right standing, we have the right arguments to make to win the case, and that matters, because I think there's a lot of confusion in the public, unfortunately, about that, and they feel maybe sometimes things are lagging when they're really not. They're just right where they are in the process. Could you expand on that? Because I think it would help the public.
Good question.
greatly.
Help us understand that process. Go ahead.
Thank you, Mr. Chairman, Madam Representative. Yes, certainly we have to exhaust administrative remedies. As I alluded to before, that includes commenting. If we don't comment on a rule, we can't sue on it later. It's no secret that we're going to be litigating the Buffalo RMP coming up. And with respect to that, we also have to exhaust all of our administrative remedies before we file. And so there are several steps in that process. It includes the governor's consistency review. It includes a final agency action. And once we have that final agency action that we determine to be adverse to Wyoming's interests, that's when we will file a suit. But there are certainly a lot of steps along the way that we have to make sure that we're preserving our standing, that we're establishing the things that we need to be successful in litigation.
Okay, good. Representative Heiner.
Thank you, Mr. Chairman. This is a list of suits or actions we have for the federal natural resources cases. I'm sure we have other cases that are outside this purview, the Title IX and all of those things that your office is working on. What percentage of your cases are federal natural resources versus other cases? Is it split 50-50 or 60? Give us an idea there.
Yeah, so, Mr. Chairman, Representative Heiner, it's hard for me to know. I don't, as I sit here today, maybe half the cases in our division are federal natural resource cases. That's just a rough guess. Within the Attorney General's office as a whole, it'd be a much smaller percentage. I couldn't wager a guess between, all the criminal cases and things like that our office handles, what percentage of those would be federal natural resource cases. But in our division, we have, just to keep this in mind, we have 2 full-time attorneys that are doing this work. And so those 2 folks are primarily who are, leading 50-some cases here.
Follow up, Mr. Chairman?
Go ahead.
Thank you for that answer. That gives us a little perspective. Appreciate that. You mentioned the Buffalo RMP that you're gearing up for. What about the Rock Springs RMP? Is that on your Periscope?
Go ahead, sir.
Mr. Chairman, Representative Heiner, it certainly is. We haven't seen the EIS on that yet, but we eagerly await opportunities to litigate those issues in the future.
Good. Okay. Mr. Luthi. Let's let Mr. Luthi speak. Okay.
Good. Mr. Chairman, thank you. I just wanted to add a little bit more. Mr. DeWald was just doing a fabulous job, but, so I hope I don't muck it up. But maybe just to give you a little on the side of the policy side of what the governor does, we follow somewhat the same process. When we see a rule in the Federal Register, we immediately make sure our agencies know about it, and we organize whether or not they're going to comment. And that's when we start working with the AG's office, so that we know that those comments, when they are submitted, at least have the advice of doing exactly, Representative Lawley, what you said, that we've identified those areas that we think that the rule may be lacking, either in terms of substance or in just flat out, error. So we can point those out in the comments. Then, when the litigation comes, that is what makes what we call the administrative record. That is what you can point back to and say, we commented on this particular point on this rule. Agency, you either ignored it or you didn't address it. Those are the kind of issues that we deal with. We have a couple of really good examples, and Mr. DeWald was just being somewhat modest. Regional haze and the ozone transport rule were really big victories for coal and coal-related resources. And I can tell you from a policy point of view, particularly in the last pick a number, 3.5 years, about any rule that came out of the EPA, we immediately started looking at. Any rule that came out of the Department of the Interior dealing with public lands and leasing, oil and gas, immediately we were looking at. Any rule that came out of any federal agency dealing with the Endangered Species Act, we were looking at immediately. So that's how we look at things from the policy side. And we're always encouraging, we're generally always pushing the AG's office, and they're always ready to help us on that. So with that, I appreciate the opportunity to expand on that a little more.
Okay, Co-Chair.
Thank you, Mr. Chairman. So pretty direct question, and yes, I'm asking you to speak for your bosses. Do you have adequate staffing? This is a pretty heavy workload to me, for 2 people, plus all the other things the AG's office does. Do you have adequate staffing? That's a question for both of you.
Yeah, that's a good question. You mentioned 52 attorneys to 50 cases. What kind of ratio is that?
Mr. Chairman, Mr. Co-Chairman, I spoke before a committee last year and stated what I think continues to be true, which is that our office has never turned down a case or a matter because of workload. We simply have never done that on the HB 300 side. I don't think we do that generally anywhere in our office, but especially on the HB 300 side. We've never declined to get involved in a case because of workload. I can tell you, in preparation for today, I took a look at our caseload back when I joined our office in 2015, and we had 22 for NERPA cases between our 2 HB 300 attorneys. So I can tell you that has kind of exploded recently. Last fall, I was counting cases, and I think we were hovering around 40. So we have gone, we're kind of going straight up the hockey stick right now, a number of matters that we're involved in. So to give you, some kind of frame of reference on caseload.
Heavy lift, thank you. Down here. Go ahead, Representative.
Specific to FERC's rule for transmission planning and cost allocation, is there any status on that? I think that came out in April. Is there any status on that with the office?
Go ahead.
Mr. Chairman, I would defer to Mr. Luthi if he can remember.
And I was going to defer to Mr. DeWald. I am going to get back to you. I know we were watching when the rule came out. I also know that the recently introduced federal permitting bill by Senator Barrasso and Manchin help address that as well. But I will commit to get that information back to you.
Thank you. Have a follow-up. Do you need anything else? Okay, committee. Before we close out, the ratio question you already answered, but let me clarify. We have to have a comment in before we can be prepared to take a case to court?
Mr. Chairman, with respect to litigating a federal rule, certainly, you have to exhaust your administrative remedies, and one of those steps is to have something that shows up in the administrative record. That's what Mr. Aluthi alluded to. Whenever one of these cases is filed, the first thing that the Department of Justice has to do after entering in their appearance is to start assembling that record with the federal agency. And if the state or its agencies don't appear within that federal record with respect to commenting, then the standing issues become ripe.
There's a process, like Representative Lawley was trying to point out, that we got to do this right if we're going to do it. I got a final question, it just caught my attention. You said you're sometimes with federal agencies or against. What puts us with a federal agency in a case?
Well, it depends on whether they make a good decision or a bad decision. I can give you a couple of examples, though, where we have supported federal agencies. The NPL project in Sublette County was a victory for our division last year, and that's where the 10th Circuit Court of Appeals upheld the BLM's decision to approve a natural gas project in Sublette County. So that would be an example of where we actually intervene as a defendant in support of the federal agency if we support that type of decision. There are other examples, though. Converse County Oil and Gas preliminary injunction would be a good example. The Thunder Basin National Grassland Plan Amendment that we were successful in that case late last year, and that was another one where we had intervened in support of the defendant federal agency.
Okay, thank you. Good presentation, gentlemen. Anything else, committee? All right, thank you. We learned a lot today out of this one. Thank you.
Thank you.
Okay. Absent the need for a health break, we're going to bring the School of Energy back up. Presentation on what you're working on. Okay, Dr. Krekta, go ahead.
Mr. Chairman, members of the committee, I'm Holly Krekka, Executive Director of the School of Energy Resources.
And Scott Quillinan, Senior Director of Research, School of Energy Resources.
And so thank you for having us. We'll move quickly, realizing we're the last thing between you and the end of the day, but we're always honored to share some highlights from what we're doing at the School of Energy Resources.
Everything will be on the screen you're talking about, right?
Yep.
Okay.
Yes, sir.
People watching and people in the room. There you go.
Yep. And so thank you for bringing up our slides, Heather. So we always start with our mission, which is energy-driven economic development for Wyoming. And then on the next slide, we just like to talk about what that means in practice. And it means projects over a wide array of energy topics that can ultimately bring revenue to the state of Wyoming based on its energy and mineral wealth. We've really grown the number of things we're working on, and we're going to talk about two specific areas on the next slide where we've expanded and created new centers of excellence. In terms of research funding, as I mentioned, we're a rather quickly growing organization, both through state and competitive grants. In our federal grants, we've had trouble moving those forward. They've been in the contracting stage for a number of times, but I think we're in the next 2 weeks, we expect to move about 72 million, out of that 72 million, about 50 at a minimum under operation. And that would be in particular the Sweetwater Carbon Storage Hub that we've been waiting to start. So at the end of the day, our goal is a tangible impact for the state of Wyoming. And so on the next slide, it's a slide that shows our centers of excellence. We're only going to go through two, and it's the new ones. And I'm going to hand this over to Scott Quillinan to talk about these and just say that we are always looking for ways that we can grow our portfolio to support the state. So appreciate the opportunity to give two examples.
Scott.
Yeah, so the committee's familiar with how we organize our research at School of Energy Resources, and it's in these clusters that we call centers of excellence. Two new areas that we're excited about that we're recently started. The first one, marked there in yellow, the first yellow arrow is our energy engagement, leadership, and careers. So if you take the E, the L, and the C from engagement, leadership, and careers, we get the clever acronym of ELC, or how we're pronouncing it, ELK. So you'll hear about the Energy ELK program as it rolls out. And it's focused on energy workforce development in existing and emerging industries. So working on what we do today in the energy workforce in Wyoming, but also thinking about as we expand into carbon capture and storage, into hydrogen, rare earth elements, all of those industries need people to work in them. Well, this center will also be focused on innovative energy-focused education. So K through 12, working closely with our community colleges, undergraduate, graduate, and even continuing education for early career professionals. One of the first, I know I'm taking longer than you wanted me to. I'll move on. It's also working on social science capacity building. So really making sure we have that support and expertise in the social sciences on our energy-based studies. Moving over to our other center that we just started, the Subsurface Energy Digital Innovation Center. This is going to be stood up by a director, Sohail Siraji in Department of Energy and Petroleum Engineering. And it'll be really working on focused on taking blockchain applications in energy. It'll be working on big data and analytics, artificial intelligence-driven novel fluids for energy applications. This is a really important, it gets down to the weeds, but that's a really important one for Wyoming. And then working on physics-driven AI applications for energy. So with that, I'll pass that back to you.
Mr. Chairman, and the faculty member that is leading that center has literally written a book called Blockchain for Sustainable Oil and Gas Production.
Could you repeat that, please?
Well, now I'm not 100% sure it's perfect, but it's sustainable, blockchain for sustainable oil and gas.
Thank you.
Yeah. So, and as we start each of these centers, our goal is to roll these out, next slide please, Heather, across the state in meaningful ways. And so this is not something we're trying to do, it's something that's already happening for projects that were started. So our carbon engineering program is again that program looking for new uses for Wyoming coal. We have a few pictures here. Construction has started for our pyrolysis demonstration. So just as a reminder, for our carbon engineering program, there's lots of different products. There's two processes, pyrolysis, which makes the char, and solvent extraction, which makes an extract that's used for asphalt. These pictures of the first system that was funded, the first demonstration, which is pyrolysis, so that technology is a little ahead, and construction's underway. I would say we asked for the funding to do this work in 2021. We are seeing the same inflationary pressures that others are seeing, so we're trying to get a handle on those. But in any case, we aim to deliver, and we'll let you know if we may need more support to do this project as committed. And operations, we're planning to start summer 2025. Going to the next slide is solvent extraction. That's our pilot that is on the University of Wyoming campus. That information will be used to design the field demonstration. It'll be next to that pyrolysis at the same location that I just showed. And we are when those of you who took a tour when you were in Laramie at the last meeting saw it was under construction, we are essentially at a point where we are pressure testing. It's not as quiet anymore. We're getting that thing up and running. So it is a process. Commissioning takes time, but that is underway today. Next slide. We've already talked about the integrated test center. So if you keep going, one more slide. The thing I wanted to highlight that's happened is what we call the ITC Technology Showcase. And so what you see are pictures of that event, which is an invite-only event where we brought in PRB users, Wyoming PRB users from across the country to learn about different carbon capture technologies. Several of these PRB users have coal-fired power plants in states that have greenhouse gas mitigation regulations or goals or some form that might be a risk to the continued operation of that plant. It's interesting, different companies have different levels of expertise in this space. So out of those 68 attendees, some were familiar with all the technologies. So what we did on this day was have actual technology vendors talk about their technologies. Everything from some that were smaller scale at the Integrated Test Center that still will take some time to get scaled up to those that are being commercially offered today. And so we had 68 attendees, 12 of them represented PRB consumers. And I would just say these represented some of the biggest coal users, PRB coal users in the country. And with those that weren't there, we are already working with them on other projects to look at options to keep their plants operating. So we are basically, through this work or this meeting, trying to support every single large PRB user in the nation. So we're really happy with how it went. The goal was to connect the technology developers with potential customers. And so those are off and running, but we're still, through funding given to us by Peabody, able to do things like independent economic analysis, CO2 storage work to support companies using PRB coal that might not have those resources in-house. So moving on. I wanted to highlight the center, a little bit of work by the Center of Energy Regulation and Policy Analysis. That's our policy group, and I know the fabulous Esther Wagner is here, who is an author on many of these reports that have been published on the SERPA website. Including the first one, which does an incredible job talking about the history of greater sage grouse management in Wyoming and really trying to get information out into the public sphere about where Wyoming has had a lot of success in protecting habitat for sage grouse. And you can see this is just a really wide array of topics. The next one is our second in the series of 6 of nuclear, our nuclear series. So this one is on supply chains and component manufacturing. The next one will be out very shortly, which will be focused on uranium production. So we have 6 of these, and we are trying to get them all done by the end of the year. It took us some time to get it up and running, but now we are getting these out. We have a paper on defining environmental justice. So that's a term that's really come up a lot lately. And we do a lot of surveys of energy communities. And what we've learned is the energy, or what's called environmental justice, it's seen very differently in different parts of the country. And in Wyoming, again and again, we see our energy communities see energy production as a positive and not a burden. And so we're trying to quantify that and show what does it mean to our energy communities to have a term like that? What does energy or environmental justice mean? And one thing we know for sure is our energy communities would like to continue producing energy. So, and if we don't tell that story, no one else will.
Thank you, Mr. Chairman. Just to interrupt for a moment, I attended a CLE yesterday that some representatives from SERPA presented, and I just wanted to say thank you because, practicing attorneys look at that information, and that very point that you just made, there were graphs about how Wyoming really does support it. So we're unique in that sense. So anyway, I just want to say thank you for taking your research out into the field where people actually practice and use that information.
Senator, for those of us not accustomed to CLE.
Oh, my apologies, Mr. Chairman, continuing legal education. So all lawyers have to get a certain number of continuing legal education hours. And I think I paid $10 for 45 minutes, and it was really insightful. So thank you.
Mr. Chairman, we try to offer bargain basement prices for CLE credits at the School of Energy Resources, and a number of our conferences also are designed to help Wyoming's lawyers get access to those credits while hearing about the work that's being done at the School of Energy Resources. And just along those lines, the other thing that this team has developed, I also want to talk about the paper Headed West is focused on Wyoming natural gas attributes. It's absolutely fabulous. Esther also led that one. And then there's a community benefits planning toolbox, which basically this is just support for energy or any communities in Wyoming. If they want to apply for federal grants, you have to come up with something called a community benefits plan. And that's a relatively new requirement, and it's not something that a lot of communities would know how to put together. And quite frankly, we didn't know how to put it together, except that Scott knows how to put teams together. And so I think School of Energy Resources now has a really robust team focused on leading those efforts. And so we've rolled that out to Wyoming's energy communities or communities in general, should they choose to pursue it. Moving on, keep going. Just wanted to highlight, we always are trying to, again, the CLE comment already came up. We have a number of conferences. To date, we've been able to offer our conferences at low or no charge. And I wanted to highlight too, of course, we love to host our legislators at these conferences as well as members of the public and students, faculty and staff from the university. On September 12th, we have a conference focused on economic geology that we do in conjunction with the Wold Foundation. And then, Mr. Chairman, you would be proud to find out that your very own Senator Ellis has been helping us to organize a tribal energy summit on October 17th. And that really stemmed from some of our students giving us feedback that we didn't have enough information provided to them on energy projects and energy development on tribal lands and tribal energy. So we are working, this is our first step towards making sure we're meeting their needs.
Thank you. Thank you, Senator Ellis.
Yeah. And then, sorry.
Go ahead.
Okay. And my last slide, Mr. Chairman, I wanted to make the committee aware, if they're not already, that we have launched a new podcast. We're always trying to find new ways to reach folks both inside and outside the state about all the exceptional energy work happening, not just at the School of Energy Resources, but across the state of Wyoming. So if you are so inclined, it's called The Energy Frontier, the Wyoming Landscape, and you can find it on basically anywhere you do podcasting. And never thought I'd be doing that in my career, but there we are. And thank you so much for your time and attention, Mr. Chairman and members of the committee.
Thank you. I'm assuming you've hosted that podcast, and whom are some of the other guests that you've had?
Mr. Chairman, generally, so we have had, we've started, I am the host, and doing my best. I'm just going to tell you, I wouldn't wish listening to yourself on any of my worst enemies, but even so, it's, Kara Fornstrom has talked me into doing this. Most of these so far have been internal folks. Let's see, I know Ashley was here earlier. Ashley Harpstreet did the Wyoming Taxpayers Association with Dawson Klusner, who we actually ended up hiring. And then the Pipelines and STEM Leadership was Karen Campbell from Enbridge. So we started the podcast really with internal folks, the School of Energy Resources, but we have a long list and it is growing. We've recorded well over 20. We've aired 12. Number 11, actually, I believe, was Lon Whitman. I'm sorry, starting tomorrow, we will have aired 12. Lon Whitman, director of the Enhanced Oil Recovery Institute, and number 12 is Erin Campbell, director of the Wyoming State Geologic Survey, and she was absolutely fabulous. So highly recommend if you're going to start, that'd be a good one, and it's on tomorrow.
Forward to listening. Thank you. Committee. Go ahead, Representative Conrad.
Thank you, Mr. Chairman. Dr. Kuka, thank you very much. It's very, very good. My question is on the second slide where it says SER in action. From a state funding perspective, $22 million, and then to the last bullet it says tangible. Can you help me understand or give us some relationship between the investment that we have made and what the tangible benefits of that has been, for lack of a better word, a return on investment?
Yes. Mr. Chairman, Representative Conrad, that's a fabulous question. So there are a number of ways to look at this. Our ultimate goal is revenue back into the state coffers. That's our goal. We have not, one of the reasons we just hired the Dawson, who's an economist, is to help us really quantify that. So it is a very difficult thing to quantify that. And let me give you an example why. And I will say, for example, we have, just in the last 18 months, successfully competed for over $85 million in competitive funding that is new dollars coming into the state, but that does not mean that it's going into the state coffers. So in terms of what goes in the state coffers, let me give you an example of why this is so hard to answer your question. The School of Energy Resources funded, this is one of our most early successes, I would say, and it's not just us, but several entities in the state funded the Center for Air Quality to work with natural gas producers on the west side of the state were having ozone events, and they were going to be shut down. And what the Center for Air Quality did was help them identify using things like planes, and now they have drones and all kinds of a van with lots of instrumentation and sensors where they had leaks occurring. When the cause of the ozone generally is VOCs, volatile organic compounds. But in the process of closing those leaks, and they were able to also reduce their methane emissions. Well, so not only are those natural gas producers not shut down and still operating and drilling today, but they have a lower methane intensity natural gas that has started to be recognized in new markets, and it's really early in that. So you tell me, can I take credit? Can we take credit? I wasn't here, but can we take credit? How much of the natural gas produced since then can we take credit for? Because really it was the producers that did all the hard work. We came up with some science and technology and support for them, but I don't know what the answer to that is, Mr. Chairman.
Follow up?
Agreed, and the challenge I have is how do we articulate to our constituents, or more importantly, other folks in the state, where the $22 million went? So my optics question is, how can we do a better job in promoting the great work you guys are doing? But right now I can't, outside of the anecdotal, as you mentioned. So is it possible to receive a report at some point that denotes of what we invested, tangibly we know what why is?
Mr. Chair.
Dr. Correct, I think that's a good approach. Is something like that possible?
Mr. Chairman, okay, I just want to make sure I understand your request, Representative Conrad, because every quarter we publish, we prepare, I wouldn't say, we actually don't publish it, but we very easily could, a folio for the Energy Resources Council. That is your board, that is our governance board, and Representative Burkhart has been on that. So it's a really unique board in that we have two legislators. The other is Senator Anderson currently, and so that's up for you to decide. But that board, we report every single project we work on, both state and non-state funded, every quarter. And so I don't know if we're at 100 projects, but there's a lot. Each one of those, we don't work on it unless we think there can be ultimate net revenue for the state. And so, but quantifying when that happens after the fact, it gets tough. So, but we wouldn't start a project if that wasn't the ultimate goal. So let's make sure we understand exactly what you're asking for.
Maybe you can get with her afterwards. I think what you're looking for are basic talking points. I attend all those meetings just because I want to know what's happening and going. Sometimes I speak above my level, but I like to be there and hear the conversation in person, and I'm assuming you would be welcome to. Let's go to Representative Lawley.
Thank you, Mr. Chairman. Thank you, Scott and Holly, for being here. I truly always look forward to your report. And one of the things I often will, in response to what Representative, what's your name again? Conrad. I'm kidding him. Conrad said, I actually do say, come watch these hearings, presentations, or even when we're in session, because a lot of information is provided that I think is helpful to the public to know. But more information would be great too, but I think it's out here. And sometimes it's good at least for my constituents, to hear it from you rather than me. And so I do really appreciate always your reports. I wanted to go back to under some of the recent publications that you have concerning the Community Benefits Planning Toolbox. Again, I really commend you for doing this. I have a little insight into what the DOE is requiring here, and how some of them have the same issue of how does that translate into Wyoming. And so I think helping communities with that is really helpful. But there's one element that is really valuable for Wyoming right now that we haven't talked about today, but we often talk about in this committee, which is workforce development is one component of that community benefits analysis and plan that they create. So very valuable piece for them to have some help often doing that, because for them to do it on their own is a big lift for them if they've never participated in that process. So when a community has an opportunity for a project sponsored or funded partly by the Department of Energy, having this I see as so valuable, whether it's translating things that we kind of go, what does that even mean in Wyoming? There's about 4 of them, I believe, but different things that are included there. But then there's things like workforce development that are really important that we somewhat, if that community is going to do that, take advantage of this opportunity. So again, I just say thank you and for doing that. And so more of a comment, but I appreciate that work, and at that granular level is very important.
Good point. Thank you. Co-Chair.
Thank you, Mr. Chairman. So Dr. Krutka, to get back to Representative Conrad's question, and I have something that I think will get there. Is SCR helping fund through all the different mechanisms, Dr. Brandt's work with filtration technology?
Yes, Mr. Chairman.
Dr. Cook, would you expand on that a little bit? Because I know that Dr. Brandt is into large-scale testing of that, which means it's getting very close to commercial activities and applications. Could you expand on that a little bit?
Mr. Chairman, Representative Burkhart. So one of the centers of excellence is the Center of Excellence for Produced Water Management. Produced water is a massive impediment to oil and gas production in Wyoming. It's very costly for our operators. That center is focused on developing new technologies that would separate produced water or treat produced water, maybe reduce the amount you would need to re-inject, thereby lowering costs. Historically, treating produced water has been prohibitively expensive. One of the things that Dr. Brandt has done, by the way, using a coal-derived membrane, Wyoming coal-derived membrane, is to start to make progress on the economics of produced water treatment by learning how to extract things like lithium and rare earths and critical minerals that could provide an extra revenue stream that would make it worth it to treat that produced water. So you're not re-injecting. And then you have a new source of water in Wyoming that could be used for beneficial purposes. You have saved the oil and gas industry a lot of money and for re-injecting, and sometimes not just money, but like truly being able to continue operating. And then you've produced some valuable minerals. So, and I think another example, while a lot of the funding for like carbon capture and storage projects has been competitively awarded to the School of Energy Resources, let me just give you one example. A single project on a coal-fired power plant in Wyoming would net the state about $180 million, and the local community about the same amount, meaning that just one project would pay for, I think it would be all the resources that School of Energy Resources has had since its inception. And we're working with all the top producers, or all the top PRB consumers, both in Wyoming and outside the state. So we do feel we have a number of ways to justify our value.
Thank you. Committee? Okay. Go ahead.
I want to go back to Mr. Luthy's comment about the Ford and Ferrari. In my opinion, the SER is the Ferrari for the state of Wyoming, and I'm extremely proud of these people.
Thank you. Good comment. Appreciate you keeping us up to date on everything, because if we're not there as a state, some other state will be. So it's crucial that what you do there. Just before the session opened, I traveled out to another state to talk to one of our big companies and say, can you slow down your closure plans? We're getting the new figured out, but don't be so quick to close the old out, because there are too many jobs, too many families affected by that. What you do, Dr. Krecht, and your team, keep us ready to move into that new, but you also find ways to preserve our old, and I appreciate that. Thank you. Okay, committee. Thank you.
Thank you.
Okay. Brian, do you want to do a summary today or tomorrow on today's work?
Entirely up to you, Mr. Chairman.
You're sharp enough to do today, if you will do it.
Let's do it. Okay.
Okay.
So, Mr. Chairman, here are the committee's actions. The committee requested to continue 25 LSO 0001 to October. That was the LMO bill draft. And then also requested a new bill draft, the only new draft that I have of the day, that would just address LMO bonding changes. The committee took no action on 25 LSO 67, which is the industrial siting payments. Unlike the other bill drafts, Mr. Chairman, I did not hear a direction to bring that to October, to bring that bill draft to October is what I understood with that.
Okay.
Yep. Then, Mr. Chairman, 25 LSO 69, which concerned the industrial siting payment tiers, continues to October. Also 41, dealing with tribal notice for industrial siting projects. The committee voted to sponsor 25 LSO 40, which was the manufacturing sales and use tax exemption. And then the committee continued 3 bill drafts, the remaining 3 drafts to October. 25 LSO 44, the industrial production exemption, 25 LSO 120, the amortization of sales and use tax, and then 25 LSO 45, the integrated test center. And Mr. Chairman, the only other note I would offer is tomorrow's start time is 8 a.m.
8 a.m.
Not
Do not
8:30.
sleep in. And if you'd be willing to share your notes, even a photo of them with the co-chairs, your summary report there, thank you. Just a photo, yeah, just take a photo of it and send it to us. Thank you. Oh, go ahead.
Just a clarification on the tribal notification on the industrial siding. My understanding is that we will hopefully have another bill draft for the Select Tribal Committee on, the Select Committee on Tribal Relations to consider that's, would allow the tribes to perhaps see impact payments. And so I just wanted to be clear that depending on how tribal relations go, our October meeting might, it maybe include both bills for our consideration, but maybe with a recommendation on which one the Select Committee on Tribal Relations would prefer. So I wanted to, I think, because when I visit with you, usually we're like, well, we need to get feedback from the chairman. So I'm just maybe
Well,
trying to get some
Brian-
direction from everyone and in the, spirit of
Take it in the direction
transparency.
that Senator Ellis wants to go there, okay?
Thank you, Mr. Chairman. I just want to clear up confusion for the members of the public who are confused out there.
Co-chair, you good? Okay, everybody's good. Anything else? 8 a.m. tomorrow, we're recessed until that time.